think you have to.
Hang on. You're saying preparing to live stream.
Yes.
Now this is looking more promising.
If it helps, I've just been asked if I consent to being live streamed. So something's happened on the system.
Yeah, I've pressed got it.
So have I.
So have I.
Yeah, okay, so I think it is. Okay.
Excellent, thank you. I'm sure we will be told if it's not live streaming, but it seems to be showing that it's live streaming. So thank you for that. There's always a glitch on the first day, so don't worry about that. So good morning and welcome, ladies and gentlemen, and for everybody who is tuning in, watching this on live stream. The time is just gone past 10 o'clock, but the inquiry is open. I've already opened it. Can I confirm first that everyone can see and hear me okay?
Yes.
Okay, thank you. Now, my name is Yvonne Wright. I'm a Chartered Town Planner, and I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Healy Development Solutions Broadway under Section 78 of the Town and Country Planning Act 1990. It is against the decision of the Council of the Royal Borough of Kingston upon Thames to refuse planning permission for the following development. Change of use of the existing 3rd to 22nd floors in Tolworth Tower from office, that's use class B1, to residential, which is use class C3. Change of use of the existing 2nd floor from office, which is use class B1, to ancillary amenity space, including a residence gymnasium and lounge, and that's use class C3. Change of use of existing 1st floor car park, sui generis, to create a flexible workspace unit, dual use class C3 and E. Change of use of part of the existing ground floor undercroft from office, use class B1, to create freestanding retail kiosks, which are use class E, with associated external facade alterations and internal refurbishment works to Tolworth Tower. Also includes the demolition of the existing retail units fronting Tolworth Broadway and the construction of 2 new buildings, which is T2, Tower 2, up to 19 stories, and T3 up to 15 stories, with residential units, ground floor commercial space, which is U-Class E, and public plaza. And the reconfiguration of the existing multi-storey car park, vehicle parking and servicing, along with the provision of associated cycle parking, refuse storage, amenity floor space, I hate that word, amenity floor space, landscaping and public realm works. And that's the existing Marks and Spencer's, Travelodge and council car park. Those are excluded from the proposals. So what I've read there is the agreed description as set out in the signed statement of common ground. And that's, the address is Tolworth Tower, Tolworth Broadway, Tolworth, London, KT6 7EL. What I will be doing first is obviously giving my opening remarks. So, and then I will be setting out the process and procedures that are going to come forward after that. So first of all, I'd just like to move on to a few housekeeping and sort of preliminary matters about this virtual event and this running of this event. Just a reminder again that this is being live streamed by the council. So the event can be viewed in real time. So just be aware that obviously members of the public are viewing this. This is a formal inquiry that I am leading and has specific rules and procedures that need to be followed. So please, I'm sure you will all be courteous and respect the formalities that are associated with this event. If some people present have never attended an inquiry before, I will be running through how the process will, how the procedures will go forward. Now, present are 2 experienced advocates who have been instructed by their respective parties, and they are fully aware of their duties to assist the inquiry and its efficient running. The witnesses also have a professional duty to help me on matters within their expertise and to answer questions openly and honestly, which obviously you would expect, in accordance with the proofs of evidence that have been submitted as part of the evidence base. As regards interested parties, and I know there are a number in the room today, those wishing to speak will have the opportunity to do so at the appropriate time. I will invite people to speak, so please don't speak unless you are invited. That will go for the advocates and the witnesses, etc. as well, so it's not just interested parties, because it is quite a formal setting. I will provide more details on how that is going to proceed. So so if anybody's not clear, then hopefully once I've gone through my opening remarks, it will be clearer. Now, unless you are speaking, if you can please keep your microphone muted to minimize any background noise and disturbance, that would be most helpful. If you wish to do so, you may switch your camera off if you are not speaking, but I don't particularly like to talk to a blank screen. So it would be helpful if at least some would keep their cameras on, but obviously that it really is up to yourselves. Obviously, when you are speaking, please ensure that you have your camera and your microphone on, please. Can you all also please ensure that any other electronic devices, phones, etc., are either on silent or are switched off? Again, that helps to reduce any interruptions. I'm aware that people are either in offices or are at home and things happen in terms of interruptions. So we will just deal with those as and when and if they happen. If anyone loses connection, which I hope nobody does, but again, it does happen, please just don't panic, just try and rejoin using the instructions that were sent through by the council again. And if you are really struggling, then please contact the council. There are some numbers on the links that have been sent through, and hopefully somebody will be able to assist you. Again, if there are any particular issues, obviously, hopefully you'll be able to access the live streaming if there is an issue. But we'll try and sort something out as soon as we can. Obviously, if you lose me, that causes a bit of an issue because obviously I need to be present to hear all of the evidence, but we'll deal with that as and when and if it happens. Before I move on, does anybody have any particular questions or queries just about housekeeping and sort of those preliminary matters about a virtual meeting that I just mentioned?
Ma'am, just may I mention one point that relates to the chat function on Zoom? I know in other formats such as Teams, when an inquiry is running, the chat function's been disabled, but I just wanted to check with the council that A, the chat function was going to be disabled, or B, if it wasn't going to be disabled, it was clear that what role the chat function was performing, because I see there's an entry in the chat function already, which was nothing to do with us, and I don't want anyone to be putting something on the chat which they don't want others to see.
Thank you for that. I was going to raise that a little bit later, but I will raise it now. So thank you for that. That was very timely intervention there. I don't want anything put on the chat. If anything is put on the chat, I will not be looking at the chat at all. It has no purpose in this inquiry. This is a formal event. It's not an event where there is chat in that sense. So please do not use the chat function. I will certainly not be looking at it at all. So I don't know, as you've just said, I don't think it's been disabled, but that doesn't mean that you can use it because it has no purpose in this event. This is not a public meeting in the same sense as other events that may allow chat facilities. Okay, so thank you for that. I will talk about now, as again, I was going to move on to that a little bit later, but I will talk now about using the hands up function. Now, I have already mentioned that people will be invited to speak. As such, there shouldn't necessarily, unless I ask a question and say, does anybody have any comments on this? There shouldn't really need to be any hands up. Now, obviously, if anybody's having any issues, can't hear anybody, or is doesn't or has a query about the process or the procedures or exactly what's going on, then please do put up your hand. That facility is obviously in Zoom. And I will come to you at an appropriate time. If you can't find for the life of you the hands up facility or whatever, then please, you can put your camera on and literally put your hand up, or just alert me in some way that you have an issue or need to or would like to speak. There, as I said, there will be opportunities at appropriate times for people to speak. So just bear with us as we go through the procedures. I want to be able to hear all the evidence that I need to hear. So everybody will have an opportunity to speak. Now, if I can now move on to appearances. I have had prior notification of the main parties, advocates and witnesses. I have received a list of appearances, or list of participants, and those who are going to appear in terms of the witnesses from the appellant. I haven't received that list from the council as yet. If that can be provided, we will be going through that list as part of my opening remarks anyway, but if the council can just put the information that I requested into an email to the case officer at the planning inspectorate, that would be most welcome. You don't need to do it now, but if it can be done by the end of today or tomorrow, that would be very helpful.
Adam, would it be acceptable? It's in my written opening, which is where I tend to put it, just to ensure it's there and it isn't then lost down the back of the sofa. Will that do?
That's absolutely fine. I just need the information that I asked, which is names. It was what the witnesses were going to be speaking on, although I'm aware of that, but obviously we will be going through that. The job titles, any qualifications, companies, etc. So as long as it's all there, as long as I have that, that's absolutely fine. Thank you. Now, although I have had that prior notification of the advocates and witnesses, names, etc., I would like, obviously, the advocates to introduce themselves and their witnesses to the inquiry for everybody's benefit who's in the virtual room, including what aspect of the case the witnesses will be dealing with. Now, following those main party introductions, I will then invite those interested parties who wish to speak, and obviously you're in the room today, to make yourselves known to me. It won't be time to discuss matters there, but it will be time to just introduce yourself and let me go through a few details with you. So if I can just firstly move on to the appellant, and could the advocate please introduce himself, confirm who he has been instructed by, and introduce the witnesses and any other persons who may be available to answer questions during the inquiry, including those for the round table sessions, please.
Thank you, ma'am. My name is Scott Linus, Queen's Counsel, and with me is my learner junior, Heather Sargent of Counsel. We're instructed by Anita Rivera and Roisin Hogan of Mishcon Dorea. And as per the list that we sent to you, ma'am, we propose to call the following witnesses. Mr. Stephen Marshall to deal with fire safety matters as one of the round table sessions. Mr. Lloyd Bush on transport planning, again to deal with the round table on that issue. Thirdly, Mr. Jonathan Lonergan, who will deal with daylight, sunlight and overshadowing issues. Fourthly, Mr. David Price, who will deal with play space provision. Fifthly, Mr. Carl Standley, who will deal with energy matters. Sixth, Ms. Ruth Shilston, who will deal with microclimate issues. Seventh, Mr. Mark Taylor, who will deal with architecture and design and may assist in the fire safety roundtable session. Eighth, Mr. Richard Ashdown, who deals with viability issues. Ninth, Mr. Piers Lee, who deals with office demand and viability issues. And 10th, Mr. Bob McCurry, who will deal with planning issues generally. I should say before finishing that introduction, ma'am, that does not necessarily represent the order in which these witnesses will be called. As you'll be aware, there are some programming issues, particularly with the third week, which may mean that we need to amend the order of our witnesses as we go, but we will make sure the inquiry is updated accordingly as we progress.
I'm aware of that. Thank you, Mr. Linus. Can I just confirm, is it Ms., Mrs., Miss for Heather Sargent?
Ms.
Oh,
it's Ms., ma'am.
Ms.
Thank you.
Lovely. Thank you. Thank you. And are you expecting any other persons to be available to answer any other queries or questions if necessary? Or is it purely just those witnesses?
We're not anticipating anyone else, ma'am, but if for whatever reason other issues arise during the course of the inquiry that you need help with, then we have obviously a team of experts that have been employed on this case, and we can bring them to the inquiry as necessary, but we're not anticipating that at the moment.
Great. Okay. Thank you. Thank you for that. And now for the council, please.
Thank you, Madam. Yes, my name is James Burton of Council. So I'm a barrister of 39 Essex Chambers. I'm instructed by the Council's Head of Development Management, Mr. Barry Lomax, under direct licence access arrangements. And I will be calling 3 witnesses who you are already aware of, Madam, and in this order: Mr. Alex Maguire of FLOH Flow Consulting in relation to energy, so heating and overheating / cooling, circular economy, although happily that issue has been resolved, urban greening, and technical matters regarding the question of an office residential mix in the Tolworth Tower. Mr. Matthew Scott of Aspinall Verde Consultants regarding viability, and Mr. Toby Feltham of the Royal Borough regarding all other issues and planning issues generally. Thank you.
And again, just the same question. Any other persons that you consider you may need to call upon to, or may be available if necessary? Or will you just introduce them as and when, if they are required?
I will introduce them as when, Madam. At this stage, we don't envisage it will be necessary to bring anyone else onto the stage. I suppose, conceivably, depending on where we get to regarding the unilateral undertaking, Section 106, might be necessary to bring someone on at that stage, but that's not envisaged at the moment.
Okay, great. Thank you very much for that. Now, can I turn to the interested parties and persons, please? Now, prior to the start of the inquiry, I was informed that the following persons would like the opportunity to speak, and that was Councillor, is it Thalen? Have I pronounced that correctly?
Yes, that's correct, yeah.
Councillor Thalen. There was also Councillor Holt, Mrs. Walker, and Councillor Dunstone. Now, I'm aware that Councillor Dunstone can't attend today, so we'll be speaking another day. And I think, Mr. Feltham, you said that she would be speaking tomorrow, potentially.
Yes, tomorrow. Yes, that's right. Yeah.
Okay.
The only other person I have is Ada Simpson.
No, those were the ones that I was informed that they were likely to speak before this morning.
Okay. Okay.
Then there were some potentials, which included Ada Simpson. There were some other potentials, but I presume they're not in the room, so I'm not going to mention them. So obviously, if they're not here, then they can't speak. Other than the ones that I have listed, is there anybody else present here today who would like to have the opportunity to speak? If there is, I don't anticipate there is, but if there is, then if you can please just put up your hand or wave at me or whatever. Okay, thank you. Can I just then go through the introduction so that each speaker can introduce themselves? And what I'd like obviously your name, whether you are representing a group or organization or just yourself, whether you are supporting or opposing. I think I know the answer to that one already, but I need to ask that question just to make sure it's clear. And whether you have submitted a statement or are proposing to submit a short statement, whether you're happy to speak this morning, because that's, I do anticipate, or I would like interested parties to speak this morning, except for Councillor Dunstone, who will do tomorrow. Whether you have any time restrictions and whether you would prefer to speak after the council has given all of their evidence to me, and the council's advocate, Mr. Burton, has gone through all of the witnesses. You can speak then instead, although I think it would be useful to hear your what you have to say now. If you do have any written statements that you're reading out, they will need to be provided. I know I do have a couple of those already have been provided to me. And then finally, if you can just confirm that you're happy to answer any questions should the appellant's advocate have any questions, if you are obviously opposing. If you're supporting, then it would be the council's advocate. But if you are opposing the scheme, if you're happy to answer any questions that the appellant's advocate may have. And just to make you aware that obviously if any speakers will be added to my decision letter in relation to who has the list of attendance, or the list of appearances, I should say, not attendance. So can I start? I'll just go down my list then. So can I start with Councillor Thalen, please? If you just want to just introduce yourself. I know I've just said your name, but if you can just introduce yourself, what in particular, whether you are, and obviously you're a local councillor, are you representing yourself or are you representing the ward or whatever you are a councillor of? If you can just clarify all the points that I've set out, that'd be very helpful. Thank you.
Oh, thank you, Madam. Good morning. As you said, I'm a councillor for Tolworth and Hook Race Ward, which is the border of Tolworth Broadway, and I'm a local resident as well. I've lived in this area for 44 years. 10 minutes walking distance from the Tolworth town. So I'll be talking about the residents and myself as a local resident.
Okay.
No opposing it.
And are you content to answer any questions should the appellant's advocate have any for you?
Okay, fine. Yeah, thank you.
Okay, thank you. And Councillor Alison Holt, please.
Good morning. I am a councillor in Surbiton Hill Ward, which is nearby, and I'm chair of the Surbiton neighbourhood. And I also live in the area in Surbiton Hill, so I'm an interested resident, and I've also spoken to local residents. I represent them as a councillor, but I can't say I'm involved in any other group beyond that. Today, you know, in terms of what I'm discussing today, I'm happy to answer questions. I can't remember what else. Was there something else you wanted me to confirm?
Well, obviously, I know it was about whether you're supporting or opposing, but I know the answer.
Yeah.
I know the answer to that, so that's okay.
Yes.
We don't need to confirm. It was just to confirm, really. Okay.
Yes, I will be opposing this current application.
Okay, thank you. And you have submitted a statement already, haven't you? So
I have submitted.
Okay.
Yes.
Okay, thank you. Sorry, Mr. Thalen, I just wanted to confirm, are you submitting a statement at all, or is it just you just want to speak today?
Well, I'll speak, and I can submit my statement as well.
Okay, so you've got something written in front of
Yeah,
you, and that would be most helpful. Thank you, Councillor Thalen.
So you want me to go ahead now?
No. I'm just going to. I'll call you in when I go through. So it will be a little while yet, because we've got other opening statements by the council's advocates, etc. So it'll be a little while yet. Well, hopefully not too long, but I will call you in when I want to hear from you. Okay.
Yep.
Thank you. Can I have Mrs. Bridget Walker, please?
Good morning.
Good morning.
Yes, good morning.
Do you want to just introduce yourself? Are you a local resident? Are you representing a local group?
Right, I'm a Mrs. Walker, age 72, a resident since 1983 at Ewell Road, Surbiton. So just down the road from the site.
So local resident. Okay. Yeah. Thank you.
And I have worked with lots of other residents from the Chessington group, but I'm the one that's speaking today, but not for them. It's just that we've combined information.
Okay, that's clear. Thank you for that. And are you happy to answer any questions or queries if the appellant's advocate has any?
Yes.
At all? Okay, lovely, great. Thank you for that, Mrs. Walker. Right, thank you. Just bear with me because I lost you all then. Okay. Thank you for that. There's nobody else who wishes to speak. Now.
Sorry, Madam Chair, myself, Ada Simpson.
Oh, Ada Simpson, I do apologise. Sorry, is that Mrs.
Ms.
Okay, would you like to just introduce yourself?
Yes, my name's Ada Simpson. I'm a local resident. I live about 300 metres or so from the site. I oppose the planning application. I'm speaking on behalf of myself, but also sharing views from other local residents who have shared their concerns with me. I'm happy to speak and will submit a short statement afterwards. And I'm happy to answer questions as well.
That's lovely. Great. Thank you for that, for confirming that. Okay. Now, as I've already said, I anticipate, or it is my intention to hear from the interested parties this morning. So you will have an opportunity to speak later this morning. And then anybody else who wishes to speak later on as well. Now, just to clarify as well, obviously you've been given an opportunity to speak this morning, but there are some roundtable sessions later on and on particular topics, which will be the fire safety standards and car parking and highway safety. I will go through some details on that a little bit later, but some of those elements between the two main parties have been resolved. But I am aware that there is local residents and concern still about those issues. So if anybody wishes to be involved in those discussions from the interested parties who are present, I'm more than happy for you to be involved in those discussions and to give any particular comments and points of view that you wish to make on there. So just to make you aware. And then if there are any aspects that later on you would like to question, because interested parties have the right to question the appellant's witnesses if you wish, then obviously if you can let the council know that you would like to attend certain sessions, I will be sending out a programme. One hasn't been sent out quite yet because it's been a little bit fluid. So a programme will be sent out, and it will continue to be a little bit fluid because that's the way that inquiries go. It depends on how long evidence in chief, cross-examination, etc. takes. But if anybody does think actually I might have some questions on that particular topic, then at least looking at the programme, you may have an idea of when you would like to attend, and you know, depending on what you're hearing from the witness, you can then ask further questions then. Is that quite clear?
Yeah.
Okay. So it doesn't mean that you only attend today. If you can, or if you wish, you can attend later on and ask questions if you want to. Now, now, obviously, I'm keen to hear the points that everyone wishes to raise, but obviously, I have read the evidence that has been submitted. So I do not want carte blanche reading of previous representations, etc. That's not a useful use of the inquiry time, and written evidence has exactly the same status as evidence that will be heard within this inquiry. So there is no distinction between the two. So all I want to hear really is key points. Okay, so and I really don't want repetition. So if somebody else has already mentioned a particular point, then it's not really useful for me to hear that point again. So because it doesn't have a purpose, and it does not make efficient use of inquiry time, which is obviously quite restrictive. So okay, thank you very much then for introducing yourselves, interested parties. If I can move on to notification letters. Now I have copies of the notification letters. That's for the appeal and for the inquiry. So thank you for that. And I have the address lists as well. So thank you very much, Council, for providing that. I also have seen copies of the representations made in response to not just the appeal notification, but for the original planning application consultation that was carried out for the decision that was made by the council on that. So I have all of that. So these, obviously I will take all of these into account in reaching my decision. And just to confirm, have the main parties seen all of those representations?
Ma'am, from the appellant's point of view, I don't think we've seen the statements that have been referred to this morning that are going to be read out for the purposes of the inquiry. I know at least one of them you may not have seen either at this stage. I'm just wondering if we could be sent copies of statements that are going to be spoken to by those who are appearing at the inquiry today, so that we can have sight of those.
Absolutely. And what I was sent them yesterday, I haven't looked at them because I don't like looking at statements, because if people don't actually then turn up, I do not want to read those statements. So I said to my case officer not to tell the council not to actually put them on their website until the actual speeches have occurred. And I don't have all of them anyway, but I haven't looked at them, so I don't know what's going to be. I haven't looked at them in. I have looked at one because the case officer had a concern about the length of it. That's the only thing, but I didn't read what was being said, only about the length of it. But those speeches will be made available as soon as the interested persons have spoken. We'll make sure that we'll ask the council to make sure that those are made available.
All right, I was just wondering if there's any way in which they could be provided so we can see what was being spoken to. But if that's not going to be possible for whatever logistical reason, we will listen. It just seems to us that it might be easier if we could take a very short break at the appropriate time before third party.
Absolutely, I'm content to do that, to be fair, because then obviously you can make notes against the what's actually being said. Now that we know that that the speakers are actually present in the room, those speeches can be made available.
Very well. Thank you very much.
Yes, please. For me
So
too.
if the
Otherwise, I'll be typing it all out.
No, there's no need to do that because they are available. Or the ones that I've seen, yes, I've seen, or I know of 3. I think I'm going to have to look myself now, just to make sure that they're up.
I don't think I've got all of them actually. So I think I've got 3 out of 5, and I think one of those is for tomorrow.
Perhaps, ma'am, we can deal with other aspects that you wish to get through before we reach the interested parties speaking, and then take a short break to gather up statements and so on.
That would be really, really helpful. Yeah, we'll do that. Okay, and move on to the proofs of evidence and statements of case. Now, I've received proofs of evidence from the appellant and the counsel. I've read the proofs and the statements of case, and again, so I'd expect them largely to be taken as read. So I do not wish to hear sort of wholesale repetition of documents. Obviously, though, focusing, I know that the advocates will be focusing on key points and highlighting those to me. That will be really, really helpful as part of your arguments. Now, the proofs and statements of case will be made available on the council's website, along with the core documents, which will be referred to during the inquiry. Now, I know that there are some other documents, and I'm trying to keep track of it, to be fair, because I'm getting a lot of emails through my case officer at PINS. I'm just looking at some of them now. What I'm going to do now is just go through the inquiry procedure and running order, because I know that there is a potential adjournment that needs to be made later today. And what I want to discuss as part of that is making the decision as to exactly how far that adjournment needs to be, because there are a couple of options. I'll explain for those who aren't aware as we go through, because there is some additional statements that have been made in relation to the discussions on energy, which is the first topic, the first issue that is going to be dealt with by the council's advocate in relation to the first witness. So because of some additional information that has been sent through by the appellant, there is a requirement for an adjournment to allow that witness to digest that information, etc. I'm going to go through the inquiry procedure and the running order as I see it at the moment. And then when we come to that point, I'd like to understand from both main parties what the situation is, and then I'll make a decision as to how far we actually adjourn for on that. But obviously we won't be adjourning until we've heard from the rest of the opening remarks, the opening introductions, opening statements, etc., the interested parties and the roundtable discussions. So just to make you all aware, I shall follow the procedure, which is in the 2000 Inquiry Procedure Rules. So that's the Town and Country Planning Appeals Inquiries Procedure Rules, which are dated 2000. So if anybody would like to have a look at those, you're more than welcome. When I have concluded these opening remarks that I'm making, I will then invite the appellant and then the council to make brief opening statements, usually around 10 minutes or so. That will help everyone to understand the main issues and the main arguments that you're going to be bringing forward with your witnesses. Then I will hear from any interested parties. So I will bring each of you in. There will then be an introductory presentation on the scheme by the appellant's architects to familiarise everyone with the proposals and the site. This has been prepared in agreement with the council. Now, this isn't sort of necessarily, or it can be normal practice now, and there will be no discussion. It's purely factual from the architect's perspective as to this is the proposal, this is the design, this is the site, etc. So it's just to give some context to the inquiry. There will be no discussion on the presentation, purely for information. I then intend to hold the roundtable sessions on the fire safety standards issue and the parking and highway safety issue. And I am obviously, I've already stated, I am aware that there is now some agreement on some of those issues between the two main parties. Now, those discussions, they're called roundtable discussions or roundtable sessions because they are more akin to a hearing. So it's more of a discussion. So there won't be any cross-examination. Now, and then after the roundtable sessions, this is where it gets a little bit more interesting. We were going to hear from the council's first witness, which is on the energy related or climate measures, as I sort of call them, those elements. But due to the submission of additional evidence relating to energy by the appellant, there is some debate now about how much time is needed for that witness to digest that information, respond, and then so that then we can resume the inquiry. Can I first of all then hear from the appellant as to exactly what this additional information is, and your thoughts on how that information needs to be taken into account as part of this inquiry. And then I will come to the council and ask for a response in terms of how long the council thinks needs to be, how long their witness needs to have in order to digest that information. So can I start with Mr. Linus, please?
Thank you, ma'am. Just to confirm, beyond the proofs in the statement of case, we submitted rebuttal evidence on viability matters and energy matters. And the information that has been provided shortly before the inquiry was a further supplementary rebuttal, both on viability and on energy. There's some other documents that I'll come back to once I've dealt with energy in particular. Now, as we understand it, there isn't an issue with the viability evidence as far as programming is concerned. We understand that the council consider it possible to address that evidence when they call their viability experts, but this will happen after the energy witness is called. We don't have any issue with that order of witnesses at all. As far as the energy statement is concerned, the supplementary statement contained information which was effectively a continuation of issues between the appellant and the council, which had not been resolved by the time rebuttal evidence was exchanged. And in discussions in preparation for the inquiry, it was felt by the appellant that there was further information that would either help resolve issues or help inform you as to how we think those issues should be resolved. We have produced that information. If the council considers that it needs more time to digest that, we suggested that, as you indicated, ma'am, we continue with the rest of the inquiry, at least until the roundtable sessions are finished today. The main issue then is what do we do to allow the council to respond to the energy evidence. Now, we do have question as to whether or not it's necessary to adjourn the inquiry until I think Thursday morning was the original suggestion from the council. The reason for that is that when one looks at the material that was included in the energy supplemental rebuttal, a lot of the pages in it were actually containing an energy master plan, which is a council document. Actually appears on the council website as part of the evidence base for its emerging local plan. And the rest of the information is really backing up a 1 or 2 page rebuttal, which continues issues that are already in dispute between the parties. And it really advances material and relates to material that's already been before the council. So we question whether it would be necessary to adjourn as long as until Thursday morning. And obviously, if the council is intending to produce further written material in response to that, what we want to avoid is appearing on the Thursday morning, hearing what the council has to say, and then there being something which then we require to respond to, which then necessitates further adjournment potentially. So our suggestion would be that we would adjourn until late enough tomorrow afternoon to allow the evidence in chief of the council to be heard in its entirety, speaking to whichever written documentation the council wants to prepare. That would then allow us to consider that overnight with a view to commencing cross-examination on the Thursday and hopefully catching up time during the Thursday and the rest of the inquiry timetable. We also bear in mind that if we're dealing with other matters at the inquiry today, including opening the third parties on the round table, then this is plainly time which Mr. Maguire can spend digesting the information and then responding to that, as well as any time that's necessary before we reconvene tomorrow afternoon. So our suggestion is that we don't need necessarily to adjourn until Thursday morning. That would obviously create further pressures on the programme in any event, but we accept that some adjournment would be appropriate if the council thinks it's necessary to digest the information that's been provided, and we would suggest adjourning until tomorrow in such a way that allows the council to produce its own evidence and response.
Thank you, Mr. Lightness. Mr. Burton, council's response on that.
Yes, thank you, Madam. Well, let me get straight to the point regarding energy, Madam. You know that we don't agree with the appellant's suggestion, and I'll now just explain why it's wrong. Could I preface this, Madam, by making this point? Given the incredibly late hour at which the council was served with this information, and I should say it came without any warning. We were not told, for example, as a matter of courtesy, by the way, we're working something up, get ready on Monday, you might want to clear your diaries for it. The council could, my submission, quite reasonably have said, absolutely not. But that's not the council's approach. It's not in the council's way of doing things to try to shut information out. That's not going to be helpful to you, Madam. It's not going to assist you to get ultimately to the right answer with the benefit of all the evidence and all the facts. So we have tried to be, I have to say, utterly reasonable and bend over backwards to accommodate this. Now, as you may have had conveyed through your case officer at PINS yesterday, Madam, possibly by a rather late email last night, the council, and in particular, of course, Mr. Maguire, continue to look through the information that had come over from Mr. Stanley and is absolutely adamant that he cannot start on this until Thursday morning because that is the time it would take. And I have to say that what the appellant, what my learned friend has just said now, rather repeats and falls into the same error that the appellant's email presentation and description of this energy information committed yesterday, because it's actually not, it's not about the, of course, rather short make text of the, as it were, the proof section. The devil is all in the appendices. Now, these appendices are highly technical. Do not be for a moment, madam, if you have it, do not be for a moment fooled by the brevity of the main text, because what follows is what purports to be, we'll come on to when Mr. Maguire gives his evidence, an electrical demand assessment at Appendix A. That's just the first item. Now, to place this in context, both procedurally and substantively, Mr. Maguire made it crystal clear in his proof, and paragraph 217 is the reference, that he was very surprised not to have seen an electrical demand analysis, because, as you'll be aware, madam, one of the appellants, perhaps its principal argument, one of them, against what we say should be here, namely a site-wide heating system, is that there is not enough capacity in the high voltage network to accommodate that. Now, one crucial element, clearly, in reaching that conclusion, or purporting to reach that conclusion, has to be, well, what's going to be the electrical demand of the appeal scheme? If you don't know that, you can't know whether or not the high voltage network does or doesn't have enough capacity. So Mr. Maguire made that point loud and clear in his proof, and we now have it purportedly. I mean, he's getting to whether it is in fact what it says it is and what it's meant to be, not in a rebuttal, but yesterday. Now, to understand an electrical demand analysis, Mr. Maguire tells me, requires quite a lot of work and consideration, not merely of the high technical document that's right here at Appendix A, but of course by reference to the I think possibly, I haven't actually counted all of them, but possibly thousands of pages that Mr. Stanley has previously submitted. And bearing in mind, this is an appeal scheme where well, for a start, we don't have one energy statement, we have two, as you know, one for the Tolworth Tower and another one for T2 and T3. But we not only have two, but they've gone through multiple iterations from the start of the application all the way up to very recent days. So this is not the work of a few hours. This is the work of a proper chunk of time, putting a cold towel on one's head and going through it and comparing it with what else is out there. That's just Appendix A. There's also, of course, now Appendix B, okay, emails don't take so long to look at. Whether they say what they're said to say and so on is another matter. But we've then got further in Appendix C and D and E, further highly technical appendices, not the least of them being Appendix D, cost breakdown, and Appendix E, plant storage capacity. Frankly, Mr. Maguire is working furiously to get on top of this. And having discussed with him yesterday, it was clear to me that A, he wouldn't be able to start before Thursday. B, he needs to have, once he's got his head fully around this, we need to have a proper discussion, him and I, about it, along with Mr. Felton, who's, as it were, my immediate instructing officer. And the best possible thing for the running of the inquiry that could come out of this, and this is my sincere hope, is that rather than have Mr. Maguire take what I suspect would be many hours in oral evidence in chief, walking you through his position regarding this information, he work up, and absolutely he needs, I've told him this, if he's going to do this, if he thinks it's the most efficient way to do it, he needs to work this up in business hours tomorrow and get it over to the appellant in business hours tomorrow. Some form of, essentially, some form of speaking document that he can use as a guide to take you through this when he gives his evidence. So there are 2 points. He needs until Thursday morning anyway. The hope is that given that time, he'll be able to produce something that will save you and my learned friend a lot of time, because otherwise my learned friend will be hearing it all from him without any kind of reference document in oral evidence in chief over many hours. So
thank you, Mr. Burton.
That's what I have to say about that one. Thank you.
Thank you, Mr. Burton. I don't actually have that document because I haven't accepted it at the moment. No. So I haven't even seen it.
No, sorry.
Because I was asking both main parties, obviously I was asking the council for comments on whether it should be, your comments first before making a decision as to whether I should accept it. Now, obviously from the appellant's point of view, you're saying that this is essential for your case. Is that the case? And that you absolutely want it to be submitted because it assists me and assists your arguments in terms of trying to move forward with the evidence. Is that the case, Mr. Linus?
In short, yes, ma'am. The most important thing is that you're helped by both parties in reaching the right decision, and we take the view that this information is necessary to assist you.
Okay, thank you. From what I've heard then, having not seen the evidence, I would need to have a look at the evidence myself, which I will ask the case officer to send it to me when we break. We will have a break shortly once both the advocates have done your opening statements. I think we will then take a break, and then that gives me time to contact the case officer, have a look at that, and then when I come back, I will make a decision on how far the adjournment should be. But I need to just look at the evidence myself as well before making that decision. But from what I've heard, it is likely that I will come back and say that we will adjourn until Thursday morning, on the basis that hopefully Mr. Maguire will have had time to not just digest the information, but to produce a written statement that will have been sent to the appellant, so that the appellants can also look at that. And then hopefully actually reduce, from what I've heard from Mr. Burton, reduce, it could significantly possibly reduce the amount of evidence in chief, etc. So there could be an element of catching up. But what I don't want to do, because this is quite, I understand that, we don't want to be delaying anything in relation to the inquiry. We all have, we all want to get through this as quickly and succinctly and as efficiently as possible. But this does seem to be an area that is quite contentious at the moment. As I said, Mr. Maguire may, depending upon what he makes of the additional information, that may change. I don't know. So let me have a look at that. So thank you for giving me both of your points of view on that point, and I will give my decision on how far the adjournment should be once we have had a break and we come back from that and I've had a chance to have a quick look. It will have to be quick, but a quick look at the actual evidence itself. Okay, So thank you for that.
I'm grateful. We're content to leave it there if you're going to look at the information, and we understand that if anything further in writing is coming from the council, that it's due to common business hours tomorrow. We're grateful for that as well for Mr. Burton. Ma'am, I wonder if now is the right time to explain to you other documents that have been discussed between ourselves and the council, which we understand were sent to PINS but last night. Would you like me to continue with that now, or would you like to come back to that at another stage?
No, I don't mind doing I was going to come on to documents and what is outstanding and what additional documents have been sent, etc. I am fully aware that some documents were sent last night. To be honest, I haven't even considered opening them. I haven't had the time to do that. So I will need, again, my own time to actually to divulge those myself. If you want to just do the documents now, I'm more than happy to do that. So, Mr. Linus.
Thank you, ma'am. There is an updated affordable housing and viability statement of common ground that's being discussed between the appellant and the council. I don't need to say anything about the contents of that at the moment because I'll cover the issue of affordable housing very briefly in opening. But that reflects what we understand to be the latest stage of discussions between the parties, and we can address that in due course in evidence, subject to any discussion, any points you might want to raise once you see the document. The second document is effectively it's a travelling draft of a statement of common ground on fire safety matters. Again, this is something which has been discussed between the appellant and the council in the lead up to the inquiry. We can update you as part of the roundtable session on fire safety matters, but given the indication at the case management conference that you wanted the statement of common ground to be used to help inform the roundtable discussions, the parties have been trying to update that in advance of the roundtable session. I think it's fair to say that hasn't been finalised as an agreed statement yet because matters which we'll explain are still being confirmed with the council, but we thought it helpful that you have that document in advance of the roundtable session to help with that. The third thing that I want to raise with you is that, as Mr. Burton has indicated already, we understand that circular economy issues have been agreed. Now, that has been confirmed by email correspondence between us and the council, but rather than bombard you with further email strings, we think it may be better to reflect that in an amendment to the statement of common ground. And we're quite prepared to do that, to keep your inbox as decluttered as possible, ma'am, if that's acceptable to you. If you would prefer to see the outcome of the email discussions on this as an alternative, we're happy to do that as well.
I'm content for an updated statement of common ground as long as that's signed and dated appropriately, so that it shows that yes, this is the agreed statement of common ground. I'm content.
Very well.
For that to be put in.
Very well. We'll take that as an action point because it's right. Those matters are agreed along with the whole life carbon assessment, where there was just a point being discussed between us and the council as well. We will confirm that by way of an update to the SOCD and take that away, ma'am.
Thank you.
I'll just check if there's anything else I need to update you on. Yes, just to confirm, although the fire safety statement of common ground is a travelling draft, the affordable housing viability statement of common ground is, we understand it, agreed.
Yes, because I did notice that this morning and did send a comment back to my case officer saying it wasn't signed or dated and it still said draft on it.
Right. Well, if that's the case, we will correct that, but the substance of it is agreed for the purposes of you understanding where the parties are. But we will correct that, and we will do that at the same time as we're updating the main statement of common ground and provide those to you together, if that helps, ma'am.
That would be very helpful. I'm just looking up I'm just making sure I'm looking at the right document. Yes, the one that I received this morning at just past 9 o'clock.
That sounds like it.
Yeah, it still says draft on it and it's not signed or dated.
Right.
So as long as there is clarity, yeah, if you could send me through a signed and dated, then I know absolutely that that's the one that's agreed.
Very well, ma'am. We'll tidy that up. And
appreciate that.
Mr. Burton nodding, I understand that's acceptable to him as well.
Absolutely, yes. Be absolutely clear, the substance of that document is agreed. It seems to have simply been overlooked, madam, but it hasn't been signed.
That's fine.
Ma'am.
Okay. I still haven't received a list of draft conditions. I know obviously that's way down the line. We won't be looking at those for a long time. Can I just ask where they're at? There isn't an urgency to receive them, but obviously I don't want them to be forgotten about. Now I understand that there's some backwards and forwards going on those conditions. Am I correct on that?
You are, ma'am. I think discussions are still continuing on some of the conditions in any event. We take the view that it's probably better just to let those discussions follow their course over the next couple of days to see if we can provide you with a document that is as much agreed as possible. There are a couple of things that are just being discussed, but perhaps we can take that away, and if we are at the inquiry on Thursday, we can provide you with a further update then, and hopefully there'll be at least a draft set of conditions to provide you with.
That's absolutely fine. It's useful to at least just understand exactly how many conditions and obviously pre-commencement conditions and all those elements that we would need to go through. But again, I certainly don't need them, and it may be something that we can, as I said, if you can just keep me updated on it, it doesn't mean that I actually need them this week or even possibly next week. Or not until later next week. So I'm content for the discussions to go ahead, because if agreements can be made on conditions, or if, and I don't like lots of conditions, I'll make that clear already.
Thank you, madam. Well, obviously, Mr. Feltham is the master of that, ultimate master of that list of conditions. He's bearing that in mind, but I agree with my lady Fred. It does seem to us, if we can have, those extra days, we might produce something more useful for you than
absolutely. I want a useful list of conditions, an agreed list. So if that takes another week or so, then that's absolutely fine. I'd rather those discussions continue. So thank you for that. I will explain to others who are listening in on this as to why I'm discussing conditions. Doesn't that mean I'm going to approve it? But no, it does not. I will go through that shortly. I haven't finished my opening remarks as to why I'm going through that. If I can just ask both Mr. Linus and Mr. Burton, are there any other outstanding documents or any other documents that you are intending to submit at all, other than what has just been discussed?
Ma'am, not at this stage. The only point that I would mention is that for reasons that will become clear following the opening, that there are potentially discussions still to take place on affordable housing viability. So although you have an agreed statement of common ground, there is still at least one area of outstanding difference between ourselves and the council, and it may be as matters progress through the inquiry that you need to receive either a further updated statement of common ground or a short, very short notice to where matters lie between the council following any further discussions. We're hoping we can avoid that, but I just raise it in case when it comes to the viability evidence, it becomes clear that you're going to be helped by, in particular, an update to the Statement of Common Ground.
Thank you, Mr. Linus. That's useful to know. Thank you.
I've obviously noted that also, Madam. I suspect I know where Mr. Linus is heading on that. Not the document from us, of course, Madam, but one query I have really, and it's a query through you, I think, for Mr. Linus. I'm not sure where we're up to at the moment, or rather where the appellant is up to with the Section 106, which of course it's always been presenting as a unilateral undertaking form of Section 106. I'm simply not sure whether we've got a final draft or what we have, frankly.
Again, I was going to raise that later when I come to discuss planning obligations, but I'm more than happy to take those discussions now. Mr. Linus, could you just fill us in on that, please?
Yes, happy to update you, ma'am. This really comes back to the outstanding difference at the moment between the council and the appellant relating to affordable housing. I'll cover the position briefly in opening, but essentially there is a unilateral undertaking that's been prepared, and the council has, through discussions with the appellant, suggested that the approach that is contained within the unilateral undertaking doesn't achieve the maximum reasonable level of affordable housing for reasons that are set out in its rebuttal evidence. And the implication is that the council is suggesting that all the affordable housing could be located in TAR 3, as it's called, with no affordable housing appearing in TAR 1. Now, we're not conceptually opposed to that, but the issue is that we anticipate that the council may want to impose some form of occupancy restriction if the affordable housing is provided within T3 alone. But at the moment, we don't know what restriction that might be. And if a restriction were, as we anticipate, to be required by the council, we take the view that that could render the scheme unviable as far as the provision of any affordable housing is concerned. Now, if at the moment, as matters stand, for reasons that will be explained in evidence, we consider that the offer that's in the unilateral undertaking is, in all the circumstances, the maximum reasonable amount of affordable housing that should be provided. But if the council is indicating that all the affordable housing to increase the habitable rooms content of the scheme should be provided in TAR 3, we'd anticipate some form of extra occupancy restriction, for example, being required by the council, but we need to know what that is in order to understand whether it could be properly included in the unilateral undertaking. So that's where we are with the UU at the moment. As I say, we're not conceptually opposed to changing what is in the UU, but we'd need further discussions with the council to understand the exact basis upon which we'd be doing that and the implications for the affordable housing provision, the scheme as a whole.
And is there sufficient time before we come to, and I know we haven't actually allocated a day to discuss matters like planning obligations, etc. It will be potentially sometime in the third week, depending on exactly where we're at. But is there sufficient time to resolve those issues?
As far as timing is concerned, I mean, I think there's sufficient time between now and the 106 for us to understand what we need to do as far as the unilateral undertaking is concerned. But at the moment, we are in a position where the council has suggested that we could increase the affordable housing provision, albeit by 0.4% as far as habitable rooms are concerned. But if that is 0.6%, I should say, but if that is where they are taking the argument on affordable housing provision, we need to know if, and if so, what restrictions they would regard as necessary in order that they could be taken into account when we're deciding what unilateral undertaking is going to say. And that really depends on us engaging with the council to understand that outside the inquiry process. But if we can have that happen, we would hope that by the time we get to Section 106 session, that gives us enough time to resolve our position.
Madam, I'm afraid, and I don't know if it's wise cross, but I'm not sure it is. What Maloney Friend has just described doesn't quite reflect the position and the discussions that have been ongoing. Now, I'll be very brief about this, but I really don't want you to take a false impression from this exchange. That the council has said and been very clear about this. It's concerned because the Tolworth Tower is the most viable, in fact, the viable element of this scheme. It is concerned that unless there is a mechanism in the Section 106 that guarantees delivery of the whole scheme, there is a real risk that someone, I'm not saying this appellant, but permission runs with the land. If permission is granted, someone will simply refurbish and change to residential the Tolworth Tower and stop there or soon after. Thereby, of course, banking, as it were, the benefit of a much reduced, on the council's case, a much reduced percentage of affordable housing in that tower compared to the percentage that would be required if an application was before you and got permission for only the Tolworth Tower. So the council's been very clear about the need for that guarantee to be written into the Section 106. And questions of occupancy condition are a sub-issue or a side issue, or possibly a simple red herring. Occupancy conditions, of course, generally being arranged on the basis that until a certain amount of affordable housing has been transferred to a registered provider, one may not occupy a certain percentage of market dwellings. Now, those occupancy conditions, certainly as the appellant is suggesting them with the appeal scheme broken down into different phases and so on, they're not actually going to give a guarantee of delivery of the whole scheme. So I think it's important to be clear about the council's concern and what it is the council considers is needed in the Section 106. Now, the appellant may, of course, disagree, but we do need to be sure that we're talking about the same concern. I should also say, Madam, it's not the council's case, not the council's evidence that delivery of affordable housing in Tower 3, which is where the council says it should be, because that is the way to maximise affordable housing, will merely make, I think what Maloney Friend said was a 0.4 or something like that % difference regarding habitable rooms. It's not, we're not talking about points of percentage difference, but anyway, I mean, that's a matter for evidence, but nonetheless.
Ma'am, just if I can respond, so I don't want to get into too much evidential detail at this stage, but I think our concern is with the suggestion that the unilateral undertaking, or indeed any control of development, could lawfully require the completion of the entire scheme. We have yet to see any explanation from the council as to how that could comply with the SIL regulations. And indeed, what we have offered as part of the unilateral undertaking so far is that 56% of the entire affordable housing for the development is provided in T1 before any market dwellings can be occupied in T1. And this form of trigger approach is commonly used in developments for the very reason that you can't lawfully require the completion of development under Section 106 obligations or otherwise. And that's really our concern with the suggestion that the council appears to be making, which is that you put all of the affordable housing in T3 and then somehow it's proper to have a commitment to deliver out every single element of the development proposal. It's not, we say, lawful to require that. And that's why this scheme, in common with virtually every other scheme involving the provision of affordable housing or involving the provision of some aspects of a scheme which is desired to be brought forward before another potentially more viable element of the scheme is dealt with through triggers and conditions or 106s. That's why it's done. The further point is that if the council is now suggesting that putting all the affordable housing into T3 is going to make more of a difference than 0.6% as far as habitable rooms, we would like to understand where that suggestion comes from and what level of affordable housing they say could be provided, because it's not our understanding that the figure is anything different to that. So I think that's my immediate response. I suspect it's something that will come out further in discussions, but we would be grateful for some further understanding on the part of the council as to why they consider a control which requires the developer to complete the development is lawful.
Thank you, Mr. Linus. Mr. Burton, anything further that you wish to add at this stage?
I point my learned friend by way of assistance to the particular facts of this appeal scheme. And Madam, as you know, the Reg 122 tests don't exist in a vacuum. They have to be applied to the particular facts of the scheme that is before the decision maker. So that's that in a nutshell is the basis on which we say, in this case, it will be appropriate to include a mechanism that, one way or the other, I mean, it's a unilateral undertaking, so the appellant bears the burden of drafting, but one way or the other secures delivery of the entire scheme, rather than what we say is an obvious risk of someone simply banking Tolworth Tower at a level of affordable housing that, I mean, at the moment, we mustn't forget, is sitting at around 10%, whereas the council's viability evidence, I'm not saying it's accepted by the appellant I don't think has actually engaged in it, but the council's viability evidence shows that if Tolworth Tower alone were the subject of an application, it would reach fast track threshold for viability of 35%. So that, I mean, facts are everything when it comes to whether or not something is within or without SIL Reg 122.
Well, ma'am, I don't want to prolong this, but obviously it goes without saying that the scheme before you that is being tested as far as affordable housing provision is concerned is the entire scheme, T1 to T3. It's not T1 on its own coming forward as an application. You must focus on the scheme in front of you. Secondly, we understand and anticipate that the council will be preparing a SIL compliance statement. We haven't seen that yet, and we're wondering when it's going to be prepared so that we can scrutinise it. Because obviously, although this is a unilateral undertaking, there are still certain requirements the council is going to have to satisfy as far as seeking contributions and seeking obligations are concerned. So we look forward to receiving that. And again, we anticipate that can be discussed between the parties in advance of the Section 106 session.
Thank you, Mr. Linus. I have seen a copy of that has been submitted, a SIL compliance statement has been submitted. I don't know if that's the most up-to-date version, but one has been submitted by the council. So I don't know whether you've seen that or whether you're referring to something else needs to be submitted.
No,
that's on our PIN system. So
we are not aware of that, and perhaps we can liaise with the case officer outside the inquiry to make sure we see that, the latest version that you've been sent.
Okay.
We'll take that away as an action point.
Thank you. Okay, if we can move on then, because I've still got various aspects of my opening statement that I would like to get through. And then we will be having a break shortly. So just in case anybody's getting rather desperate, because we have been online for an hour and a half. But these are important points that we need to, that I need to ensure that I understand. So thank you for your patience. Now, as I said, after the break, I'll come back and say whether exactly how long we're going to be adjourning for, etc. That was the point that we got to when I was going through the way that this inquiry is going to proceed. So depending on whether I say tomorrow or whether it's going to be Thursday, the council will present their case first. So just to make it clear, the council will do all of their witnesses first. The appellant's advocate will then obviously, which is Mr. Linus, will then obviously have an opportunity to cross-examine each of those council witnesses. And then the council's advocate, Mr. Burton, will then ask or have the opportunity to ask further questions on re-examination of each of his witnesses. And then after all of the council's evidence is given, there will be then the opportunity for the appellant to do the same, to present their evidence in chief, and so forth. So the council's advocate, Mr. Burton, will then be cross-examining those witnesses, etc., etc., and then there will be re-examination by Mr. Linus. Now, interested parties who indicate that they do wish to attend later sessions, and I said I will make that much clearer once a draft programme is produced, which will follow, which it'll probably be made available sometime tomorrow morning, hopefully, or later today. As I said, you do have the opportunity to ask questions of the appellant's witnesses if you so wish. Okay, but obviously you need to be present in those sessions to do that. Obviously, if I have any questions, I usually ask them either after evidence in chief or before re-examination. So after the cross-examination is normally, unless there is some clarity on a point and I need something clarifying at a particular point, but I don't like to interrupt the flow of the advocates and the witnesses. So I will do it at an opportune time, etc. I've already talked about the roundtable discussions on conditions and planning obligations. Now, just to make it clear, those are standard procedures. I have to go through that. It doesn't indicate that I've made up my mind on the case at all. It's to ensure that I have the necessary information in front of me so that I can make my decision. So it's ordinary, it's standard procedure that I go through all the planning obligations and all of the conditions to ensure that if I were minded, and I'm not saying that I am, but if I were minded, then I have all of that to approve, to allow the appeal, then I would have all of that information there. But it doesn't mean that I have made up my mind on the case whatsoever. Okay. Now, in terms of costs, now neither party has submitted any applications for costs. and I'm not inviting any applications. But if anyone does intend to make an application for an award of costs, and that needs to be done before I close the inquiry. So it doesn't need to be done now, but it may be done later on, depending upon how the inquiry proceeds, etc. Now, in addition, just to make you aware, and as you're fully, as some people in the room will be aware, I do have a power to initiate award of costs myself, whether or not any applications have been made. And if I were to do this, it would follow a written process with the relevant party after the appeal decision is issued. Following going through the roundtable sessions on planning conditions and the planning obligations, and considering costs, etc., I will then hear closing submissions from the council and the appellant's advocates, and I will obviously require those in writing. Now, the actual dates for when we're proposing that haven't been confirmed yet. That's why there's an element of flexibility to the programme, but that will be determined as we go further through the inquiry. As regards arranging a site visit, just to make you aware that I have already visited publicly accessible parts of the site and the surrounding area on my own. That was completely unaccompanied. Nobody knew when I was visiting, etc. So I was able to do it on my own. And so I walked around the site, walked into some of the shops, walked along the streets, went up to the and walked the surrounding area, went up to the Alexandra Park, etc., and went to the station and saw the site from lots of surrounding areas. So just to make you aware that I have done that unaccompanied site visit. Now, obviously, I wasn't able to access private areas, as you would expect, because I would need to have permission to do that. So if the main parties, I don't need an answer now, but if the main parties consider that it's absolutely necessary for me to see the site from private areas, i.e. from Tolworth Tower itself, from inside the tower, obviously I've only seen it from outside, then I will need to arrange another visit, and I will on that occasion need to be accompanied, because obviously I would be accessing private land. I would need to be accompanied by both main parties. Okay, so when we come to that point of discussing site visits, if you can let me know your thoughts on that, or you can let me know at any time your thoughts on that. That would be most helpful, because obviously I would have to arrange that to make another visit to the site. Now, obviously, if I were to make another visit to the site to access private areas, that's the only reason I would be going there, is to access those private areas. There would be no discussion on the site at all about the merits or otherwise of the case. It would be purely for me to see the physical features and the views, etc., that are necessary, that are deemed to be necessary by the main parties. Now, obviously, if another site visit does go ahead, interested parties may also be able to attend. And I put may there because obviously it is at the discretion of the appellant if it's accessing private land, because obviously permission would need to be provided. And if interested parties were allowed, then it would only be one or two. I can't have a whole swathe of people coming along. It just doesn't work very well. There's no discussion at all. It's literally for me to just see elements of the scheme. So in terms of the inquiry procedure and that element of how the inquiry will run, does anybody have any comments or queries on that at the moment? I'm going to move on to the programme in a little bit more detail and time estimates and elements like that now. Okay, can't see any hands up. Okay. Now, at the moment, again, I said at the beginning, this is slightly fluid at the moment. The inquiry at the moment, I anticipate well, it's scheduled to sit for at least 8 days, and that's over a 3-week period. So it's 3 days this week, although it may not be, depending upon my decision about adjourning. 4 days next week, and then we're going into the 3rd week, and there's 1 day at the moment. That's just dealing with the witnesses. Obviously, there will need to be additional days to deal with the other matters that have been highlighted. So it'll be more than that. So it will be either, it may need an additional day to go through the roundtable discussions on the planning obligations, the conditions, and for the advocates to do their closing submissions. We will, I don't know if the advocates have had a chance, or both main parties have had a chance to look at the timetabling, and I know it's dependent upon the decision about tomorrow, but whether they have considered how long they would need to, because it's about ensuring that you have enough time to do your closing submissions. And I would like to have those closing submissions available in writing so that on the day I can go through them in writing. So again, I don't necessarily need an answer today, but it is something that I will need an answer on pretty shortly about a potential date as to when that will occur, whether it'll be in the 3rd week or whether you're now moving into a different week to provide those closing submissions. So if you can work together on that to give me a potential date, because I need to look at my work program. That's what I'm a little bit concerned about as we sort of move forward. I just need to know when, because mine gets filled up very quickly, as you can imagine, as I'm sure yours does. So can you, I don't know if you've got any inkling of that now, or whether you need to think about it because it's dependent upon the delay potentially tomorrow, etc., etc. So,
I mean, we're alive to the issue of closings, and we will reflect on that. I think the main driver for it is the realization that we are, I think, inevitably going to go into the 3rd week now. As we've indicated before, that is likely to have an influence on the order in which we call our witnesses. I've flagged this to Mr. Burton because obviously we don't want to take him by surprise in terms of the order in which we're calling our witnesses, but we have some availability issues in the 3rd week, which mean that we're going to try and ensure that you hear from Mr. McCurry and Mr. Lee by the end of the 2nd week, and we will then have to take other witnesses who are currently programmed for the 2nd week and potentially move them to the 3rd. But I will make sure that I speak to Mr. Burton about that whenever we realise what that order is going to be, so he's not disadvantaged. If we do go into the 3rd week, it's really a question of how far we go, bearing in mind that, as you've mentioned, there will need to be discussions on Section 106 obligation and conditions. So if we ended up going into, say, the Wednesday of the 3rd week, we just need to ponder whether closing that week, even at the end of that week, is feasible if you're going to receive written submissions that assist you. And I'm aware that Mr. Burton by that stage will have essentially cross-examined several witnesses of mine and may not welcome having to close immediately after the end of the evidence.
That was my thoughts.
Yeah, so I think I just need to discuss with him. We're alive to the issues. We have our own difficulties after the 3rd week, which we're going to have to think about. But rather than deal with that now, we'll come back to you when we've had a chance to reflect on that.
Okay, thank you for that. Thank you.
Yes, well, I'm grateful to my learned friend. Obviously, the sooner I know the order of his witnesses, the better for all concerned, for obvious reasons. Yeah, I should say, madam, my preliminary view on this point regarding delay between the close of all other matters and actual closings is that it would be great. It would be great to have a clear day to work at them. I would hope that would be sufficient, but yeah, one can't, with this many witnesses, one can't quite say anything with absolute certainty.
Well, that's why I would like you to work together to try and come to some arrangement. And even if a day is set, I would like a reserve day as well, and set in the diary, and non-movable, that element, so that, because then it makes it all clear that just in case we need an additional day because of the amount of evidence and closings and elements that we need to get through, that would be really useful. I know that the third week is a bit of an issue for some because obviously it's half-term week, but that's just the way the cookie crumbles, if I can say that. The fourth week, if we go into the fourth week or the fifth week, as I will call them, so you're then going into early November, that's workable for me, looking at my program at the moment, but I need to know sooner rather than later because things are getting put in. So if I would ideally like to know or have an understanding by, it'd be nice if I can have an update on that by the end of this week, for instance.
Yes, ma'am, if it helps, obviously I'll discuss with this person, but the fifth week is simply not an option as far as I'm concerned. I have another case on the fifth week, and there's potentially an issue with at least part, if not all, of the fourth. So I'm trying to resolve that at the moment. But I've taken
I'll leave that one with you then to try and come to some form of conclusion. Thank you, thank you. Now, as I've already intimated, there is a sort of a draft programme. I know it's not been published, it's sort of made public at the moment because it is still quite fluid, but it will be made public and put on the website. But again, it's a draft programme, so it will probably end up changing slightly anyway. But the advocates have provided time estimates for evidence in chief, cross-examination, etc. So obviously, if the advocates can keep to those timings as far as they possibly can, then obviously that would be most appreciated. Now, in terms of timings, now today we started at 10 o'clock, but other days will always start at 9:30 unless there is a particular reason why it can't, just so that we can try and just add an extra sort of, half an hour to the day to try and make best use of the time that we have. Now, each sitting day is divided into 3 sessions. Ideally, it doesn't quite always work like that, of approximately around sort of 1.5 hours or so, because there's only so many hours you can sit in front of a computer or a tablet or whatever, staring at screens. So we need to think of everybody's sort of welfare in terms of having breaks from those screens. Now, except for today, the sessions will ordinarily be 9:30 to 11, 11:30 to 1, and then the afternoon session, so that's the morning sessions, and then the afternoon session will be from 2 o'clock or around 2 o'clock. Try and stick to the actual time, depending upon where we are in proceedings. Finishing, if it's 1.5 hours, then it's finishing at 3:30. Now, I am aware that there may be a need on some days, and I'm not advocating all days, for that to just be extended, maybe to 4:30. I certainly don't want to go beyond that. And if there is an extension to times on the afternoons, then there will be a shortish break of about sort of 10 minutes or so, just so that people can just get up and walk around and move away from their screens, etc. So obviously the start time is set, so it will be 9:30 on each day, but the rest of the time will be a little bit fluid as to exactly when those breaks will be. But I will ensure that breaks occur at appropriate times, and the advocates will assist me on that in terms of when those breaks occur. So just so that you're aware. Now, in terms of the plans, we've gone through the documents. In terms of the plans, the statement of common ground helpfully sets out the list of plans. I have copies of those. I've looked at those. Now, I don't propose to go through that entire list. There is a lot of them, existing and proposed plans. But can I just confirm that those plans listed in the statement of common ground are the correct ones, and they are the ones on which both parties agree, and that I must determine the appeal on. So is that correct?
Right, yes.
Yeah.
Yes, ma'am, thank you.
Okay, thank you. So I'm just going to go through main issues, and then you'll be pleased to hear that that will then conclude my opening remarks, and we will have a break then. So I'm just going to run through this first. So my case management conference summary note set out potential main issues, and these were whether the proposal makes adequate provision for affordable housing, taking account of the relevant policies of the development plan and the viability of the development. The second one was the effect of the proposal on employment and retail land supply and the vitality and viability of the district centre. The third one was whether the proposed development makes adequate provision for housing with 3 or more bedrooms, taking account of the relevant policies of the development plan, the location of the site and the housing needs of the borough. The fourth one was the effect of the proposed development on the character and appearance of the area. The fifth one was whether the proposal would provide acceptable living conditions for future occupants with regard to the provision of outdoor, private, communal and play spaces. The sixth one was whether the proposal would provide acceptable measures in relation to zero carbon, the circular economy and the urban greening factor. The next one, the seventh one, was whether the scheme would provide acceptable car parking levels and the effect on highway safety. The next one, the ninth one, was whether the proposed development would provide acceptable fire safety standards. And the final main issue, potential main issue, was whether impacts of the proposed development would be appropriately mitigated. Now, these all reflected the main reasons for refusal set by the council. I also recognise that other matters have been raised by third parties, and where relevant, these may also be discussed because obviously third parties are present and may raise them. The inquiry will also obviously look at any benefits that will be weighed in the planning balance, including any implications of not proceeding with the scheme. Are there any comments on the main issues as set out at all? No. Okay, thank you. So you'll be pleased to hear that that concludes my opening remarks. So before we take a break, and that, can I just ask whether anybody has any queries or comments or questions that they have about the procedure or what they've heard this morning so far? No, got no. Okay, thank you. Well, when we come back, I'm going to adjourn now for half an hour. We're going to have a half an hour break. When we come back, I will then ask the advocates for the council and the appellant to make short opening statements. And then if there is time before lunch, then I will ask interested parties to or start to bring in interested parties. And then we will continue with interested parties this afternoon and then have the design presentation. Okay, so if the time is now 11:52 on my clock, So if we can be back at 12:22, please, or let's say 12:20. That's easier for everybody to remember. Otherwise, everybody will come back at different times. So if everybody can come back at 12:20, please. If you can please turn your cameras off and put your microphone on mute for now, because obviously be aware that this is live. So I will see you back here at 11:20 at 12:20. Thank you.
Bridget, just say you're showing us Teddy.
I know, because when I went to sign in again, I fiddled about and it just said Teddy. It didn't say my name.
I'll change it. I'll change it.
Yeah, the IT guy changed it, but not at the front. At least I'm back on.
So, Toby.
Oh, hello.
Hi. Oh, sorry, I think we're going live again. Doesn't matter. I'll speak to you.
Okay. For some reason, my video has failed.
Welcome back, everybody. Sorry, I was hearing some. Does somebody have any issues?
I've just got my video seems to have failed partway through the first session, and I can't work out how to get it back on. I'll see if I can join again using another device, but obviously I can't leave. I don't think, because I'm not sure whether I don't.
Sorry, is that Mr. Feltham speaking?
Yes, it is. Sorry, yes.
Okay, don't worry. Sometimes just clicking on video and then clicking off again and doing it a few times gets it back on. But if not, if you can resolve it over the lunch break.
Yeah, I will try.
But don't worry about it for now. Okay, thank you, ladies and gentlemen, for coming back so promptly. I do appreciate that. What I would like to do is ask the appellant's advocate, please, to make a short opening statement.
Thank you, ma'am. I've prepared an opening statement in writing that we will send to Pins on the other side. I'm quite happy to continue with the statement whilst that is being done or before it's done, if that's acceptable to you, ma'am.
Yes.
Okay, thank you.
That's fine.
Ma'am, this appeal scheme proposes redevelopment and refurbishment of the Tolworth Tower complex, designed by Richard Seifert in the 1960s and, when built, an important and visionary commercial centre. Whilst Tolworth Tower itself, which has come to be known as T1, remains a valued landmark in the skyline, the office space that it provides has suffered from long-standing and chronic vacancy levels and is no longer fit for its intended purpose. Despite lying at the heart of Tolworth District Centre with the Marks and Spencer anchor store, the overall complex is tired and in severe need of renewal to provide a lively and secure range of uses for its long-term future. The appeal site is situated within the Tolworth key area of change and also within a housing opportunity area. Tolworth is now part of an opportunity area in the London Plan, where significant residential development is being encouraged as fundamental to wider aspirations for regeneration. Within the Council's core strategy, Tolworth Tower is also identified as a gateway and strategic landmark. The scheme will regenerate the quality and diversity of the entire complex and will secure its landmark importance for the future. It will deliver 499 homes across T1 and the two new build towers, called T2 and T3, in the evidence, with high quality open space transforming the site at podium level. New retail space and public open space will be delivered in the form of a public plaza on Tolworth Broadway with flexible workspace in Tower 1. The scheme will create a mixed and balanced new community in Tolworth, generating significant economic benefits. The proposals before this inquiry followed two previous decisions of the Council, whereby it resolved to grant planning permission in 2016 for the comprehensive redevelopment of the entire complex, a scheme which established the principle and benefits of tall buildings other than Tolworth Tower on the site. And secondly, in 2019, for the conversion of the office floor space in T1 into a build-to-rent residential scheme, and we'll return to these decisions during the inquiry. The successful regeneration of the site is important to the realisation of the Council's own vision for Tolworth for significant new housing developments at the complex within a strengthened district centre with high-quality new development and a high-quality public realm. This acknowledged and clear need for regeneration of the site correlates with the housing need position in Kingston. There is no dispute that the Council is unable to demonstrate a 5-year supply of housing. Current figures show it's falling well short at a 3.5-year supply. The new housing targets in the London Plan are yet to make their way into updated local development plan policy, but will require a substantial uplift in new development well beyond what the core strategy envisaged. The case for granting planning permission for residential-led mixed-use development on the appealed site is a very compelling one indeed. This is the right development in the right place at the right time. The Council has nonetheless sought to oppose these proposals on a variety of grounds which do not bear proper scrutiny. They're reflected in your main issues, ma'am, and we will deal with them in detail over the coming days and return to them in closing. So at this stage, it suffices to set out briefly our position on each. First, on affordable housing provision. This first main issue corresponds with the Council's first reason for refusal, and that originally contended that the appellant had failed to demonstrate, one, that the scheme would be deliverable, and two, that the scheme would provide the maximum reasonable amount of affordable housing on site. The deliverability issue has fallen away, as the Council statement of case confirmed. And as for the amount of affordable housing, much progress, despite what you've heard this morning, ma'am, has actually been made on this issue. It's not necessary to record the detail of discussions that have taken place over previous weeks, but in short, the benchmark land value of the site and the main viability appraisal inputs, including construction costs, now agreed between the appellant and the Council. So the scope of issues that often take up significant inquiry time on viability has been substantially narrowed. The appellant's offer is for the provision of 50 units, 34 London affordable rent, 16 intermediate, equating to 10% affordable homes measured by units and 10.4 measured by habitable rooms. Now, there are two areas of outstanding difference with the Council, but we say only one is of direct relevance to the inquiry, ma'am. The first is a disagreement on the extent to which the Community Infrastructure Levy, SIL, will be payable, and this relates in particular to the applicability of a deduction in respect of existing floor space in T1. But ma'am, that issue does not need to be resolved now because it's agreed that Section 106 obligations will provide for two alternative versions of the offer that reflect the difference between the appellant and the Council, with the appropriate option following from the later determination of SIL liability under the SIL regulations. So that is not an issue with which we say you need to be concerned. The second area where agreement has not been reached relates to whether the provision of affordable housing should be split between T3 and T1 or not provided in T1 at all, and the implications of these different approaches. As I said before, it's not entirely clear at this stage if or to what extent this issue will remain a source of difference between the parties, but we'll deal with it briefly here in any event. In short, ma'am, notwithstanding progress on the agreement of viability appraisal inputs, the Council questioned how affordable housing proposed in T3 would be secured given the potential for the development of T1 to come forward discreetly. Now, the appellant had always proposed the scheme as a phased scheme, but in response to the Council's point, amended its appraisal to provide a significant amount of affordable housing, 56% of the total for the whole development, before any market housing could be occupied in T1. In reply, the Council has argued that this approach would not achieve the maximum level of affordable housing because it would reduce provision, not in terms of units, but to the tune of a total of 6 habitable rooms, a reduction of 0.6%. Now, as necessary, Richard Ashdown will explain how this split in provision affects the overall valuation. But if the Council is now suggesting that all of the affordable housing should instead be provided in T3, we had anticipated, at least at the time of preparing the Statement of Common Ground and in this opening, the Council may seek some form of restriction on occupancy to ensure delivery of these units. That position, as expressed by the Council most recently this morning, may be slightly different. But as far as the appellant is concerned, we're not conceptually opposed to providing the affordable housing in this way, but if restrictions were to be imposed for reasons that Mr. Ashdown can explain, it could have a very significant impact on the viability of the scheme, and with it the delivery of any affordable housing at all. And as we said earlier, we're not convinced at this stage that it would be appropriate in accordance with the SIL regulations to effectively require us to positively commit to complete the entire development, if that is the approach that's being advocated by the council. We therefore remain to be satisfied that a proposal which delivers the strong benefit of a substantial proportion of affordable housing up front should be questioned or changed to try and deliver 0.6% more habitable homes, when this could fundamentally affect the overall ability of the scheme to deliver any affordable housing at all, and when it would not be reasonable to positively require us to complete the entire development. Now, we anticipate that there may be further discussions with the council on this issue, but if not, and as matters stand, we consider that in all these circumstances, the scheme as currently proposed accords with policies H4 and H5 of the London Plan, DM15 of the core strategy, the Mayor's Affordable Housing and Viability SPG, and the MPPF. I turn then to the effect of the proposal on employment and retail land supply and the vitality and viability of the district centre. And ma'am, as you've indicated in that broad issue, can be split into employment floor space, first of all, which I will deal with now. Core strategy policy DM17 protects employment land and premises in the district centre, but it explains that alternative uses can be acceptable if it's been demonstrated by sound evidence and rigorous marketing over a number of years, up to 2, that there is no quantitative or qualitative need for a range of employment uses. London Plan Policy E1 identifies Tolworth as an area of low commercial growth potential and high residential growth potential, and it says that existing viable office floor space capacity should be retained, but that surplus office capacity should be released to other uses. Its redevelopment, intensification, and change of use, including to housing, is supported, provided the scope to reuse otherwise surplus large office spaces for smaller office units is explored. As Piers Lee will explain, Tolworth is not a recognised office location, and it's a challenged submarket, particularly when compared with more highly ranked and established markets such as Surbiton and particularly Kingston, which, as the council has recognised, is the obvious focus for new office development in the borough. In Tolworth, there is a very low uptake of office space, and this underlying lack of demand generates little supply of quality office space. High vacancy levels have been a significant issue in Tolworth Tower itself for a number of years. The original designs come under substantial strain as the office market has developed, given demands for more open plan working spaces with modern ventilation requirements and ceiling heights. The secondary nature of the approach to the entrance means that it lacks the prominence that an office building should provide. The mixed-use nature of the wider estate, including the relationship with retail servicing, presented an ongoing challenge as reported in successive office viability reports which considered the future of the tower. The marketing of the T1 office space over a decade, up to the end of 2018, has demonstrated the lack of demand for space within the tower, including for space as small as 300 square feet. Nothing in the market has materially changed since then, as Mr. Lee will explain, in a wider picture of historic and continuing decline in the market. Taken as a whole, the tower is now functionally obsolete from an office perspective. It can neither be split up feasibly into sufficiently small spaces to cater for what highly limited small-scale uptake there is locally, nor can it be viably upgraded to attract occupiers capable of taking its space, even if Tolworth as a location could attract such demand in the first place. Mr. Lee acknowledges that for the purpose of assessing the viability of providing affordable housing, a report on the current valuation of the tower assumes some demand for budget space in part of the tower on its upper floors, with the remainder mothballed. And ma'am, this is the report which generated the benchmark land value that's been used as a basis for the viability discussions. However, these assumptions would not address fundamental issues either with the overall building or with Tolworth as an office location. Any such demand, particularly when seen in the wider context of Tolworth's recent lettings performance, would, if realised, be likely to be short-term, and any further deterioration in the market or in the retained part of the building would see this disappear. it would be a high-risk, short-term solution at best. It would see little value or income generated in return for the costs which would have to be incurred when the future market or even partial occupation of the tower would be highly uncertain, calling into question whether any current or future landowner would proceed with any occupation at all. The assumption of basic space being occupied in only one part of the building does not, on a realistic view, offer the funding or profile that would allow Tolworth Tower or Tolworth to present itself over the longer term as a secure and enduring office location. In fact, to the contrary, it would do far more to reinforce a continuing sense of decline here. Allowing its reuse for housing, with some 529 square metres for new flexible floor space that would be available to address any local demand in the event that it did materialise, offers far more to the district centre now as part of the overall regeneration of the complex than the uncertain and partial retention of this outdated office space over the longer term. As the Council previously accepted in relation to 2019 resolution, the loss of office space within T1, and I quote, would not represent a significant loss of desirable commercial space, close quotes. The market factors which led to that conclusion remain the same now. The GLA supports the proposal to change the building's use to provide a high-density, residential-led mixed-use development, and they are right to do so. Turning to retail floor space, the scheme provides ground floor retail frontage that will serve Tolworth Broadway, replacing, at the instigation of the Council, the existing facilities, which are only partially occupied, with 2 new and fit-for-purpose retail units measuring 298 square metres. The scheme also proposes an allocated space for 3 pop-up retail kiosks and the creation of a 300-odd square metre public plaza, which will provide a supporting leisure and community function and a flexible space to host events. The modest reduction in retail floor space from just over 920 square metres at ground floor will not have an adverse effect on the vitality and viability of the district centre as a whole. The extent of active frontage will remain similar, and it will face onto a plaza that will encourage visitors to dwell in an attractively designed area of public realm, serving as a clear and distinct benefit to the centre. The introduction of residents in 499 new homes will also provide a strong boost to activity there. Overall, for reasons that will be explained further by Mr. McCurry, the replacement retail provision and the creation of the new public plaza are wholly within the desired outcomes of London Plan Policy E9 and Core Strategy Policy CS12 and DM19. The GLA has also supported the proposals in this respect. Now we turn now to the issue of whether we make adequate provision for housing with 3 or more bedrooms. The third main issue relates to reason for refusal 3, which is that the scheme's contrary to policy DM13 of the core strategy, because we haven't demonstrated to be unsuitable or unviable to provide a minimum of 30% of dwellings as 3 or more bed units. Ma'am, overall, 6.8% of the scheme's new dwellings are proposed as 3 bed, albeit that 14% of the affordable housing and 20% of the London affordable rent homes in particular will have 3 bedrooms. As Mr. Ashdown and Mr. McCurry will explain, the provision of a higher percentage of 3 bedroom plus units approaching levels of policy compliance would have a substantial impact on the development value of the scheme, making the provision of affordable housing unviable. The Council resolved in 2019 to approve provision below 30% in the refurbishment scheme on viability grounds. A similar approach should be taken here. Now, this on its own is sufficient to justify the proposed provision, but the site is unsuitable in any event for a minimum of 30% 3-bed units. The structure and layout of the tower imposes its own constraints on the form of residential units that can be provided within it, as well as its ability to accommodate private balconies. Other site constraints limit the potential to provide for much higher levels of family occupation, including car park capacity. And the core strategy, when dealing with the Tolworth area of change, explicitly recognises the need to provide for family housing with gardens outside the district centre. And when resolving to approve previous proposals in 2016, the Council concluded that the provision below 30% would not conflict with policy, given the extent of family housing within the wider area taken as a whole. Nothing has materially changed on the ground since. It should also be recognised that the scheme offers the prospect of freeing up existing family housing by attracting those wishing to downsize. 21% of the scheme's units are 2-bed, 4-people units. So we say it's been robustly demonstrated that a minimum of 30% would be both unviable and also unsuitable, although either string to our bow would be sufficient to ensure that the scheme complies with Core Strategy Policy DM13. We now turn with the effect on the character and appearance of the area, ma'am. It's common ground that the scheme conflicts with London Plan Policy D9B3, but this is purely because the council has not yet identified any suitable locations for tall buildings in its development plan. However, the council considers the overall height, mass and scale of T2 and T3, along with T1, to be acceptable in terms of visual townscape impact. And as with the GLA, they accept that there are material considerations to support the proposed tall buildings in this location. These include, as the GLA identified, the site's town centre location, the precedent of the existing 22-storey T1 on the site, and the site's planning history. There is no contention before the inquiry that any policy conflict in this respect should have any bearing on the appeal. Moreover, in general design terms, the scheme has been regarded as acceptable by the council and the GLA, with the exception of the matters raised in the reasons for refusal relating to amenity areas as far as environmental factors and a shortfall of provision are concerned. I'll come to these in the next main issue, ma'am, but any recent attempt in the council's planning evidence prepared for this inquiry to question the architectural merits of T2 and 3 is wholly unjustified for reasons that Mark Taylor will describe, but the council's own earlier approach to the scheme already makes clear. As Mr. Taylor will explain, the scheme design has been based on a rigorous understanding of the site in the wider context, including the opportunities for T2 and T3 to respond appropriately to the influence of T1. This is thoughtfully conceived architecture of a high standard that will have an unquestionably beneficial effect, breathing new life not only into the dated landmark of Tolworth Tower, but into the placemaking of a tarred site within the wider district centre. The council singularly failed to recognise these benefits in opposing the scheme. I turn then, ma'am, to whether the proposal would provide acceptable living conditions for future occupants with regard to the provision of outdoor private communal and play spaces. Ma'am, as I've identified, this issue encompasses more than one sub-issue raised through the reasons for refusal, and I'll cover them separately. I'll deal first with residential amenity space and play space. As David Price will explain, the proposals for residential amenity space and play space have been developed to achieve a successful balance between children's play and adult recreation and amenity, layering and combining activities to create a multifaceted contemporary urban garden that makes efficient use of space within this district centre location. Under the council's residential design SPD, the scheme is required to provide around 5,500 square metres of residential amenity space, with communal and private amenity space being combined there. The play space requirement for the scheme based on mayoral policy is 1,285 square metres. The scheme meets those requirements on the basis that mayoral SPG promotes the use of multifunctional space, encompassing play space and other forms of shared communal space, which together offer a range of recreational opportunities for all ages. Private balconies, mainly but not exclusively in T2 and 3, communal space at a high level in T2 and 3, and a significant communal provision and podium combined to create a varied series of high quality spaces for the enjoyment of residents, including informal and formal play, allotment space, and an informal walk. We say the council is wrong to discount the multifunctionality of the space, but even if any overlap were omitted, the shortfall at around 1,000 square metres would be justified in this case by a number of factors. Policy follows common sense in recognising the need for flexibility in provision, in particular because context is key both in relation to the site and the wider area. The site by its nature has its own constraints, including a restricted ability to provide balconies in T1, and it's part of a complex that's already partly in use within a wider district centre, such that there are inevitably some limitations on the space that can be provided. Further, the scheme does not begin and end with the above measured space in catering for the well-being of its residents. Although not counted within the calculation, there is internal amenity space, which will plainly provide wider opportunities for recreation, and the Pocket Plaza, whilst a public space, offers a further choice. These spaces, totaling over 800 square metres, will serve to mitigate any perceived shortfall, which overall should not be given any substantial weight if it be found to exist. Sunlight overshadowing next. The original reason for refusal 5 of the council asserted that the assessment of the sunlight and overshadowing was incomplete, as it was put, based on the absence of a small area at the north of the podium level from the analysis. Mr. Lonergan undertook additional work which demonstrates the scheme's amenity space fully complies with the relevant BRE guidance. 53% of the podium and 56% of the combined amenity areas meets the BRE 2+R sunlight amenity target on March the 21st, as against the guideline figure 50% set by the BRE. And as he'll explain, further analysis shows that an even wider area approaches this 2R figure in a way which will not be materially recognisable as different to those occupying this space. And that's even at the March 21st date, which doesn't capture the improvement in light conditions that will occur as the year progresses and the likely use of the space increases. As for wind, reason for refusal 5 also takes issue with the results of the microclimate assessment of wind comfort levels of standing for areas of amenity space. Ruth Shilston has undertaken a robust assessment following an industry standard methodology to address these claims. Her overall conclusions, based upon her detailed experience of assessment work, is that a simple fixing on a standing result in isolation is misplaced, and that the scheme would provide more than acceptable living conditions for future occupiers. Standing conditions are reported for some locations on the podium deck, but these are in areas where residents are expected to be ambulatory or more active. In the upper level amenity spaces, standing conditions are reported for some locations, but they only marginally miss the desired sitting criteria threshold in some areas, and they remain entirely appropriate for their function. In addition, a thermal comfort assessment demonstrates that due to the high degree of direct solar gain which reaches the amenity spaces, the overall comfort conditions are excellent. I turn then to energy-related matters, which picks up issues relating to zero carbon, the circular economy, and urban greening. And I deal with zero carbon first. The energy statements produced as part of the evidence of Mr. Stanley demonstrate how the requirements of London Plan Policies SI 2, 3 and 4 have been met. The Council's main concern here appears to be that a site-wide approach has not been adopted within a single energy strategy. We say this is misconceived. A comprehensive proposal has been produced for the entire scheme, recognising the different aspects of development across new and existing buildings. The strategy involving gas-fired boiler and air source heat pump provision in T1, as well as air source heat pump in an ambient loop system in T2 and 3, is consistent with the objectives of the energy hierarchy. The viability of a singular heat network for the entire scheme through the provision of site-wide ASHP in an ambient loop system has been investigated. However, there's just not sufficient electrical capacity to provide it, and it would be unviable as well as costlier to the occupants to do so. An alternative hybrid of ASHP and gas-fired boiler provision would not be feasible due to site constraints, but in any event, analysis shows it would emit a comparable amount of carbon emissions to the proposed approach under the scheme. There's no sound reason, we say, to reject the proposed strategy. The Council is also incorrect to say that the cooling hierarchy hasn't been followed. And as Mr. Stanley will explain, the energy statement identifies how each step in the hierarchy has been followed, and together with the evidence of Mr. Stanley, it explains and justifies the requirement for cooling throughout the scheme. I can touch very briefly on circular economy. We produced a revised circular economy statement, and our understanding this issue has now been agreed, and we reflect that in the statement of common ground. So all the requirements of London Plan Policy SI7 have been addressed. As for urban greening, the urban greening factor, or UGF, of the scheme was increased from 0.1 to 0.21 during the determination period for the application. We've subsequently established that the UGF could be increased by an additional but marginal 0.01 if a single opportunity for vertical urban greening within the scheme were utilised. We recognise that this falls short of London Plan Policy G5 and the recommended target score of 0.4, but it's justified by the constraints of the existing level 2 structure and its loading capacity. The GLA, as the body responsible for the urban greening policy, is satisfied with the scheme's urban greening proposals, and we say there's just no good reason for the council to take a different view. It suggests that there is scope for further planting because the structural capacity of the car park might be greater than assumed, or it could be reinforced. But the evidence will show, ma'am, that proper analysis of the building and the implications of reinforcement, in particular on the car park space below, disproves that suggestion. I can deal briefly with car parking and highway safety. This issue corresponds to reason for refusal 6, which alleged that hadn't been demonstrated the scheme would avoid increasing on-street car parking stress and harm to highway safety. Following further discussions based on the contents of a transport statement prepared by the appellant, this issue has been resolved. The council acknowledges, ma'am, that the parking or highway concerns identified in the reason for refusal can be properly addressed through planning conditions and Section 106 obligations. The obligations make provision to secure a car club for residents, as well as a contribution towards the implementation and monitoring of a controlled parking zone in the vicinity of the scheme, with restrictions on the ability of residents to hold parking permits. And it follows, we say, that the scheme will comply with policy DM 9 and 10 of the core strategy and paragraph 109 of the framework. I turn then to whether the proposed development will provide acceptable fire safety standards. The council's position has been that the GLA is the leading on this issue, which relates to reason for refusal 9, and whether it's been demonstrated that the scheme will satisfy the requirements of policy D12 of the London Plan. Steve Marshall, who you will hear from shortly, ma'am, will explain as necessary how compliance with policy D12 as well as D5, B5 of the London Plan has been achieved. The GLA in recent comments toward the end of September identified 3 outstanding issues: evacuation lift provision, 1; secondly, alleged absence of a single fire statement for the scheme; and thirdly, alleged absence of a single third-party suitably qualified assessor. We've addressed each of those. A single fire statement for the scheme has been produced. Mr. Marshall, on behalf of BB7, is a single third-party suitably qualified assessor, although the responsibility lies with BB7 generally in any event. And thirdly, the evacuation list provision made by the scheme, we say, accords with policy for reasons that we can explain further in the fire safety session. We say it follows that the requirements of policy on fire safety are satisfied. Ma'am, as you've indicated, there was another issue about whether impact of the proposed development would be appropriately mitigated. We say this main issue has been addressed through the production of draft 106 obligations in the form of the unilateral undertaking. The reason for refusal in relation to this issue had been focused solely on the need to secure the financial contribution that's necessary to mitigate site-specific primary healthcare requirements arising from the scheme. That financial contribution is secured through the undertaking, and it requires the contribution to be paid to the council prior to occupation. So we're not aware of any outstanding issue in this respect. We're aware, though, that obviously, as we've indicated, there's a main outstanding issue in relation to affordable housing provision, which affects the obligations, but that doesn't strictly relate to this original reason for refusal, or therefore to this issue as composed. So we say this discrete issue should drop away. So, ma'am, in conclusion then, we'd say that the Council accepts, as it must, that the tilted balance applies to this case, given its inability to demonstrate the requisite 5-year housing land supply. And on any sensible view, these proposals offer substantial benefits: the rejuvenation of a valued and architecturally distinguished landmark, the introduction of much needed housing, renewing tired and vacant office space, the optimised development of a brownfield site in an accessible location, the provision of modern retail units related to an attractive new public realm, bringing vitality to the district centre, new flexible workspace, and a high quality contemporary urban garden. To the extent that a report for current valuation purposes has assumed some demand for office space, or there is a perceived shortfall in open space provision, and there's an absence of a locational policy for tall buildings in the core strategy, these limited potential policy conflicts have to be set against the overwhelmingly positive benefits held in prospect by the regeneration of the complex as a whole. We say the scheme is in general accordance with the statutory development plan taken as a whole, and in any event, the Council's case comes nowhere near establishing that the adverse impacts of the scheme outweigh the benefits, let alone doing so significantly and demonstrably. In short, ma'am, there is a compelling case for allowing this development to proceed. We will therefore, in due course, respectfully request that the appeal be allowed and that planning permission be granted. Thank you.
Thank you, Mr. Linus. If I can now turn to the Council to give your opening statement, please.
Thank you very much, Madam. As with my learned friend, I will just ensure that I too have prepared a written opening, and I will just ensure that Mr. Feltham has it and distributes it now to save everyone's pens. So if you are content, Madam, I will begin whilst Mr. Feltham is in the process of circulating that.
I'm content for that. Thank you, Mr.
Thank you very much, Madam. I'm grateful. So this is, Madam, the opening statement, the written opening statement on behalf of the Council of the Royal Borough, Kingston upon Thames. The site at issue in this inquiry is at the heart of Tolworth District Centre, and the R. Seaford and Partners, I actually believe that the architect was George Marsh, actually, but there we go. Tolworth Tower here is an iconic landmark for miles around. It's precisely because of the site's importance that it is imperative the town and country planning system deliver the right solution here. Unfortunately, the appeal scheme does not, and it should be refused permission. The appeal scheme's shortcomings, Madam, have been succinctly identified through the application of development plan policy and the MPPF, leading to the Council's reasons for refusal. Now, a number of the reasons for refusal that turned on a failure of documentation have now been resolved, or mainly resolved as between the main parties, albeit belatedly, through the appellant's submission of further materials. And to tick them off, that's reason for refusal 6, concerning flood risk, 7, concerning traffic, so that's parking in highways, and 10, as regards the mechanism for healthcare requirements. And the circular economy elements of reason for refusal 8, along with the whole life carbon enveloped within that. Now, whilst the Council considers the information which have been provided earlier, it's helpful, of course, that those points have now been cleared away. As regards reason for refusal 9, fire, the main parties, as you've heard, Madam, they are in ongoing discussion as to whether the information now received means that can now be resolved. The question, Madam, is whether it can be addressed through conditions. The issue turns, as I understand it, on the number and adequacy of evacuation lift. Given the discussions going on back and forth as at today, and given, of course, the roundtable that we will shortly be having, this opening, Madam, does not address that issue further. However, of course, the reasons for refusal that capture the appeal scheme's fundamental shortcomings, those all remain, and the Section 106 planning obligation that the appellant is advancing on a unilateral basis does not save the scheme through mitigation, but the contrary. I address policy guidance in short order. For the purpose of the overarching Section 38(6) test set by the Planning Compulsory Purchase Act 2004, the relevant development plan here comprises the Kingston upon Thames core strategy of 2012 and the London plan of 2021. As, Madam, to your inquiry issues and as to the outstanding reasons for refusal, in a nutshell, development plan policy requires proposals maximise the delivery of on-site affordable housing against a target of 50%. Preserve employment space here in this particular location, protecting it from change of use unless it has been, quote, demonstrated by sound evidence and rigorous marketing over a number of years, up to 2 years, that there is no quantitative or qualitative need for a range of employment uses. And that's in the context of a broader policy drive to retain viable office space, including through refurbishment and repurposing of large office spaces for smaller and low-cost spaces. Policy requires proposals protect the vitality of the town centre through preservation of the shopping frontage for predominantly retail and the predominance of the retail offer, giving particular support to convenience retail in such as district centres, and that proposals achieve a minimum of 30% 3-bedroom or larger units, unless the site is unsuitable or it would not be viable to do so. That proposals deliver tall buildings in plan-led locations, and that they achieve a certain quantity of outdoor amenity space / play space, and ensure it is of sufficient quality, and that they comply with, amongst other things, zero carbon and urban greening goals. Now, of course, I've not read out the various policy references there, Madam, but I hope they're of assistance in due course scattered in the square brackets. It's also the case, of course, as regards your inquiry issue 9, that harms or potential harms that cannot be suitably dealt with by condition should be addressed through suitable mitigation via an appropriate Section 106 planning obligation. Now, there are good and obvious planning reasons for all of these requirements, and they are consistent with the NPPF. And it's not the case that the site's town centre location justifies, for example, the dilution of the requirements for 3-bedroom plus units or outdoor amenity space, play space, zero carbon and urban greening. On the contrary, this site's location means it bears a particular responsibility. Against that backdrop, I, on behalf of the Council, advance the following propositions, issue by issue. As to issue 1, the appeal scheme does not provide the maximum viable amount of affordable housing. And note, of course, the policy test here is no longer maximum reasonable, but it's maximum. It's a deliberate shift in the London plan wording. Instead, the appellant has recently moved affordable housing around through amendment to the scheme from T3, which was the position at the start of the appeal, to a split between T3 and the Tolworth Tower, the effect of which is to reduce the amount of viable affordable housing without justification. Now, the appellant's reasons for the shift are unclear. My learned friend has just mentioned some, and I think Mr. Ashdown did so yesterday in his material, but suppressing affordable housing in this way results in a clear policy clash. Now, it's also the case that whatever the maximum viable amount of affordable housing ultimately proves to be, and that's of course after the seal relief position crystallises and after viability review, it seems inevitable it will be a long way below even the London Plan fast track threshold of 35%, let alone the target of 50%. Now, the council harbours grave concerns that even the modest around 10% of affordable housing offered may not come to pass, given the draft section 106 does not require delivery of the whole scheme, and it's the Tolworth Tower that is cross-subsidising T2 and T3. And of course, the Tolworth Tower that in isolation could support the threshold 35% fast track level of affordable housing, as opposed to the 10% scheme-wide with T2 and T3 included. The appellant's recent shift of affordable housing doesn't address the council's concern regarding this risk that only the Tolworth Tower element would be delivered, which outcome, of course, would have a range of serious planning implications. Now, the appellant has said very recently, it's made the shift in response to the council's concern. But if so, the concern and the response are, that should say ships. It says ships, but they are ships passing in the night because it doesn't address the concern. That's issue one. As to issue two, an employment space, the appeal scheme proposes the net loss of something in the region of 250,000 square feet of office space in Tolworth Tower, in the heart of the town centre, in this designated employment location. And we say it's striking. The appellant continues to deny that there's any employment designation in play here, despite the wording of policy DM17, and also despite what's shown on figure 21 to the core strategy. Yet the evidence here is the opposite of evidence of lack of demand, because the appellant's own viability case is predicated on office demand for half the building. So over 100,000 square feet of office. And that is in the context of an absence of rigorous marketing over the past however many years. And the last such evidence, seemingly, is an April 2015 marketing report. The appellant presents matters, of course, on the basis that the remaining half of the building would be mothballed. This is its viability case. And that there are insurmountable technical obstacles in the way of splitting the Tolworth Tower between office and residential use, so to use the whole thus retaining off employment space. And that's a curious position in circumstances where all that the appellant's office viability evidence addresses, of course, is office below and residential above. So it's actually, in terms of the location of the offices, it's the opposite of the position the appellant says is technically impossible. And particularly so, given residential above and office below, which, madam, in brackets, is what the appellant says is technically impossible, was precisely what was proposed in the full 2015 application, the subject of a resolution to grant, and no such incompatibility was suggested there. The reality is there are no insurmountable obstacles to retention of a significant quantum of office space in part of the Tolworth Tower, with residential in the rest. As regards the dispute, there is a dispute between the parties regarding the nature and effect of the London Plan Opportunity Area policy. That doesn't assist the appeal scheme. Even if the opportunity area had been defined and included the appeal site, and of course its boundaries and whether it will include the appeal site are not known, that wouldn't justify the loss of employment space. I add, opportunity area here would drive growth, drive housing growth, wouldn't justify loss of employment space. Not if that employment space is viable. That's my one addition, madam. Should be my one addition. I'll resume in my text if you're ready. As regards loss of shopping frontage and ground level commercial floor space, as well as first floor, the appeal scheme represents a terrible missed opportunity. It proposes a pocket plaza that results in a significant reduction in both shopping frontage and commercial floor space. Yet the plaza is modest in the extreme. It offers only limited public amenity benefit. And it's actually very interesting to compare this with the Marsh Seaford original creation, the Fountain Square, in front of what was then Fine Foods, but is now the M&S car park, of course. And its commercial floor space offer is limited to non-continuous units around this square, broken by such as residential lobbies, and it's only at ground floor. Issue 3, as regards 3-bed plus units, location in the district centre is no sort of excuse for failure against policy, let alone delivery of only some 6 to 7%. The shortfall against the policy minimum of 30%, which minimum is supported by the local and the London schmars, and endorsed, of course, by the Surrey House Inspector, who considered this issue in the context of Kingston upon Thames Town Centre, is staggering, and no case has been made that it would not be viable to increase that percentage. It's not the case, moreover, that if a scheme cannot provide 30%, then any attempt at the target should simply be abandoned. Reliance on decisions for different schemes that either predated the 2016 schma or the Surrey House decision, or involved a far higher percentage of 3-bed plus units, or demonstrated it would be unviable to provide more, or more than one of those, do nothing to assist the appellant, nor do arguments based on the physical limitations of Tolworth Tower, given the inclusion in the appeal scheme of T2 and T3. Issue 4, there is conflict with the London plan-led tall buildings policy, as the borough hasn't undertaken the tall buildings locational assessment required, which conflict the council must acknowledge. However, the council has consistently acknowledged that there are factors that favour tall buildings at this site, and that conflict with the plan-led approach is far from the centrepiece of the council's reason for refusal 4. I come on to that in issue 5, because as regards outdoor amenity play space, the appeal scheme falls well short of requirements. Now, the borough requirements are agreed in the Statement of Common Ground at 6,694 square metres. And it is the case that in this field, local requirements trump regional London plan figures. The shortfall, clearly, it's over 2,000 square metres, which is unforgivable of itself. But that's in circumstances where wind and daylight/sunlight issues, microclimate issues essentially, not least by reason of the physical impacts of the new build T2 and T3, mean the quality of the space will be borderline at best. And to take one striking example, one of the 2 areas of dedicated children's play space will be entirely in shadow for the great majority of the day for at least half the year. And this is in circumstances where the nearest public park, which is Alexandra, is 0.4 of a kilometre and multiple road crossings away. The appellant's attempts, I should say, to justify the shortfall on the basis of that they're based on double counting, the so-called multifunctionality. That attempt is impermissible. Issue 6. As to energy, remarkably, in this day and age, the 3 towers wouldn't share a heating system. The Tolworth Tower would have a gas-led system, and T2 and T3 a heat pump ambient loop system or systems. Why this should be so has not remotely been justified. It appears even now, despite the events of yesterday, albeit the council continues to consider that material. The striking circumstances here are that a standalone gas-led heating system was fully worked up for Tolworth Tower in isolation for the 2018 Tolworth Tower only application. And then the energy proposals for T2 and T3 were worked up separately for this scheme. And the Tolworth Tower gas-led system has, in essence, been carried on into this scheme simply with a garnish of heat pump. It's not by accident that there are separate energy statements for the different elements. Now, yesterday's last-minute provision of many highly technical pages regarding energy from the appellant is unfortunate, and it's also unfortunate, to say the least, that the appellant has claimed that this material, which, as I've already explained, madam, says it's concerned to present an assessment of electrical demand, has claimed it arises out of the council's rebuttal evidence rather than any earlier document. Now, on the contrary, Mr. Maguire's proof could not have been clearer on the point. See, for example, this paragraph 217, the need for an electrical demand assessment was identified in no uncertain terms. Now, of course, to establish the electrical demand associated with thermal energy generation, you first must establish the thermal demand. But even now, despite yesterday, it appears this has still not been provided. So, in short, even what the appellant presented yesterday appears, at least at first blush, to fall well short of justifying the appellant's approach. It's a case of assertion rather than substantive justification. But for now, the council must reserve its position. Now, as regards overheating/cooling, again, it's a tale of opportunities missed or seemingly not considered. The same is true as regards urban greening. Now, the appellant, as my learned friend has noted, it does now acknowledge one additional surface that's fit for further urban greening. That's in the additional report from Mr. Price that's appended to Mr. Stanley's rebuttal proof. But it continues to fall well short of target, and that remains without justification. The various climate-related requirements in the development plan and its associated guidance are not merely nice to do, they are necessary. Issue 9, the council's concern here regarding the risk of delivery of a part only has been made clear. And note, that concern doesn't relate solely to affordable housing, of course, though that is the fundamental aspect. So, looking at the benefits and the balance, madam, against these serious shortcomings, the appeal scheme offers absolutely a large number of housing units. And that's a matter of significance in any circumstance, but particularly so given the borough's lack of a 5-year housing land supply, which of course engages the NPPF Para 11D tilted balance. But otherwise, the benefits are limited because the minimal number of larger, i.e. 3-bed plus units, means that it's not even the case that the units that would be delivered would be matched to the borough's obvious need. And that's even before the reality that a development with only some 10% affordable housing will fail to deliver mixed and balanced communities. Nor, madam, do you have before you a design that might be said to offset the negatives, because, and can I actually add this text, noting what my learned friend said about this. The council's been clear all the way from its statement of case. This is a matter that is a planning balance matter. That's all I wanted to add in the text, madam. Next to the, we say, the striking beauty of the Tolworth Tower, and notably its side piece. I'm back in my text now, madam. Its side piece cantilevers, those side plates that look a bit like the Eiffel Tower, and the piers that raise the body of the structure off up the ground. The new build T2 and T3 would present as generic tower blocks, lacking any obvious celebration of Tolworth Tower, other than by dint of, frankly, bland non-competition. Now, just reflecting first, it's not always helpful, of course, to ask why it is a scheme has come to be advanced with shortcomings, and you, madam, must judge what is before you. But in this particular case, it may be instructive because, firstly, it's obvious that the appeal scheme has quite obviously not come about as a holistic scheme. It's come about through the appellant seeking to add T2 and T3 to the entirely separate 2018 application for change of use of the Tolworth Tower alone, albeit that 2018 application isn't the subject of grant of planning permission, only a resolution to grant. Now, that this has been the approach is apparent from various of the documents, including the entirely separate, non-contemporaneous, separately authored energy statements produced for, on the one hand, Tolworth Tower, on the other hand, T2 and C3, and also the various descriptions scattered through the appellant's documentation of this appeal scheme as somehow phased, with Tolworth Tower as phase 1, despite, of course, that forming no part of the description of development. Second, it seemingly as a consequence of this approach, whilst the appellant's viability case depends on Tolworth Tower having a positive value as offices through the letting of the top half, there's been no serious attempt to explore opportunities to reserve office space through a mixed use for Tolworth Tower, despite, as I've said, that being exactly what the 2015 scheme proposed. And as I've said, mixed use is dismissed on technical grounds that are assertion rather than the result of a considered analysis. And thirdly, and the council is increasingly concerned about this, that there appears to be a wish to facilitate build out that stops short of building out the entire appeal scheme. And again, the fact that we have these separate heating systems for Tolworth Tower and T2 and T3, that Tolworth Tower is cross-subsidising T2 and T3, that in isolation it would be required to deliver affordable housing at 35%. They're all cause for concern in this respect, as of course is that the draft section 106 doesn't contain a mechanism that addresses this risk, despite the council making its concerns abundantly clear. And as to those concerns, we say that given, in particular, the reality that if Tolworth Tower were delivered alone, it would provide the threshold amount of affordable housing, given that it's cross-subsidising T2 and T3, the council's concerns here can hardly be considered fanciful. In any event, the appeal scheme's manifold conflict with the statutory development plan and its obvious harms mean that the application of the section 38.6 test points decisively to dismissal of this appeal, and that's despite the appeal scheme enjoying the leg up provided by the MPPF para 11D tilted balance. And in due course, madam, we will invite you to so conclude. I end with this reminder for members of the public, if I may. The council's reasons for refusal are clear. Its case has been set out in its statement of case. Some issues have fallen away, as I have explained, but the public, it's vitally important the public bear in mind that if they have issues with the appeal scheme that fall outside the council's case, they must not rely upon the council to take those points on their behalf, because it won't happen. I'm very grateful, madam. Thank you.
Thank you, Mr. Burton, for that. As it's heading towards 1:30, I am proposing to break for lunch. Now, before I do, I did say that just before we had the morning break that I would tell you about, I would look at the supplementary evidence in relation to energy, and I would make a decision about how long the adjournment would be. I have made the decision that the adjournment will be until Thursday morning. That is on the basis of what Mr. Burton said in relation to Mr. Maguire, the witness, Mr. Maguire, would be able to not just provide, not just look at the evidence and digest it, but would be able within business hours, and exactly within those business hours would need to be determined, but would be able to provide that information to the appellant, so that there would then be no delays on Thursday in relation to being able to do the evidence in chief for Mr. Maguire and then go straight into cross-examination. So that is on the basis, that's almost conditional on that basis, because I don't want any further delays. So as long as that occurs, then I am content with adjourning. We will adjourn later this afternoon when we have completed interested parties and the design presentation. So we are slightly over time, but that's okay. We will work with that. So that's my decision. So there won't be any sessions tomorrow. Now I realise, Mr. Feltham, that Councillor Dunstone was supposed to be speaking tomorrow, and I know that she's not available on a Thursday. So would that cause concerns to Councillor Dunstone? I'm more than happy to hear what Councillor Dunstone has to say next week. Obviously, it would be next Wednesday, because obviously we're not sitting this Friday. So
yes. So yeah, Councillor Dunstone said she was unavailable 2 days of each week.
I think she said Tuesday and Thursday was the note I got. I may be wrong on that.
Yeah, my memory was Friday, but I might be wrong. So,
if it is Friday, then I would be content for if she can come and give her speech first thing on Thursday. That would be ideal.
Okay, so yeah, I'm just looking at her email now. So it says that she is in her off at work on Tuesday and Friday, but she works from home other days. So Thursday should be okay, but I'll confirm with her.
Yes, if you could, that would be really helpful, because I don't want to miss hearing what Councillor Dunstone has to say. But as I said, it doesn't really matter when the evidence is given, as long as it's given within the time. Can I? So obviously I've got interested parties here who've been waiting very patiently, but this has taken longer than anticipated. So what I'm proposing to do is that when we come back after lunch, and we will be taking an hour's lunch, so we'll be coming back at 2:30, we will go straight into interested parties. Okay, those who so thank you very much for your patience. Those who need to go sooner, I will ask you who needs to, in case there is something else you need to do. So I don't mind which order people go in. Okay, whether you wish to discuss that amongst yourselves, I know you're not in the same room, obviously, but you can always contact each other, or I will just ask when we come back. Okay, and then we will have the design presentation. So we will be staying on longer today, because I do want to get those, the interested parties and the design presentation done today. And then we will adjourn until the following Thursday.
The round table sessions, ma'am.
And the round table sessions,
Yeah.
Sorry, I'm getting distracted here. I do apologise.
That's okay.
Yes, and the round table sessions. Yeah, I will have a look at the order that I want to do things, because obviously I want to be able to have a break, but basically I want to finish those sessions. So it could be that we stay on considerably later today than our initial timings, but we will see how that goes. I'm not anticipating that the round table sessions will go on for too long, because I want people to focus on the key outstanding issues and the key points. And I know that the key outstanding issues and points in relation to car parking and highway safety will come from interested parties, not from the council anymore, because that's been resolved from your perspective. So on that point, can I adjourn now for lunch? And if everybody can come back, please, at 2:30, and we will start with interested parties. Thank you very much.
Thank you, ma'am.
Thank you, ma'am.
Welcome back, ladies and gentlemen. Thank you for returning so promptly. Can I just check, we're going to move on to the interested parties, but can I just check, have the main parties received the interested parties' speeches? They were supposed to have been sent through.
Yes, so oh, can you hear me? No,
I've frozen. Is everyone else frozen?
We could hear you, and then you turned your mic off, Mr. Felton.
Okay, it's reverberating, isn't it?
If everybody mutes except Mr. Feltham, including myself, then if Mr. Feltham, do you want to try again? Do you want to speak, Mr. Feltham?
Can you hear me?
Yes, there is feedback.
Okay, I'm going to just.
Mr. Linus, are you back on now with us?
I hope so, ma'am, but the connection's very poor. I missed a lot of what you said at the beginning, and I haven't heard too much of Mr. Feltham. I don't know if it's an issue.
No, we were just trying to sort out. Mr. Feltham was trying to say something and wasn't, so nothing's been said at all. We're just trying to sort who can speak and who can't, as in.
Thank you. It looks to have improved.
Hear whom. Excellent. Okay.
Okay, shall I try again?
That sounded fine then.
It's partly because of my video problems. I've not been able to get the video working on my other one, so I've got it on going on 2 screens. So if it doesn't work,
yeah, that can cause feedback.
Yes, but it's okay now, is it?
It is at the moment, yes.
Great. Okay, well, I've probably solved it. I think I might be talking through one of me and being seen through another of me. But
that's fine. Whatever works. That's fine. Excellent.
Okay.
Thank you. So sorry. So my question was: have the main parties received the interested parties' speeches? I've got a nod from Mr. Linus because my case officer sent them through.
So so there was I think I was sent three.
There are 3. Yes.
And then I had another 2, which I think I forwarded on some of those. So let me see who should I have forwarded those to, because I suppose, is it better to have all 5 together and send that out around to everyone? I don't think they've all come as one, but.
Ma'am, I have 5 different documents here, if that helps.
That's fine. So if everybody's got the 5 versions, I know we don't need 5, we need 4 today, because obviously Councillor Dunstone is going to speak on Thursday now. That's fine, and they can then go on the council's website. Okay.
Yeah. Just to say, Councillor Thailand is no longer going to speak because he thinks his issues are being covered by the other 2 councillors.
Right. Okay. That's absolutely fine. Well, what I'm proposing to do, unless there's any other queries or issues, I would like to bring in Ms. Simpson first, because I know that she has informed my case officer that she needs to go early. Is Ms. Simpson in the call?
Just admitted her, so she wasn't.
Excellent.
Supposed to join.
Right. Okay. Obviously left and came back again. Ms. Simpson.
Apologies, I was just having some issues with my connection there.
That's fine, no worries at all. We've not properly really started. We were just all trying to sort out and ensure that everybody's got everybody's speeches and that everybody could hear and see everybody, because I think there were a few glitches there. But I will now formally resume the inquiry now that we've got everybody in the room. What I had just said was I want to move on now to interested parties. I've just been informed that Councillor Thalen won't be speaking. And I know that the case officer has informed me that you need to leave early, Ms Simpson. So I was going to suggest that you spoke first, so that then if you needed to leave, you could, but at least then you've been able to put across what you want to in your speech. And then I will go to the other interested parties who are in the virtual meeting and hear from them. So are you happy to start first then, Ms Simpson?
Yes, I am.
Thank you.
I'll go ahead now then.
Yep, absolutely. Thank you.
So I introduced myself earlier, but as a reminder, I'm speaking as a local resident who lives really close to the site, and I oppose the application. I have been a bit poorly myself, but I think it's testament to how concerning these plans are that I have done my best to be here today and to share why I think that these towers would be so damaging to both local residents and the local area. I have submitted a short written statement this morning, so I won't sort of read exactly from that, and I'll try to speak briefly. There are a range of serious issues that I see here, and that a range of other local residents from across Tolworth, Surbiton, Chesington and Kingston have shared with me. And I know that a lot of those have already been covered and that other interested parties will no doubt focus on these. They include the height of the towers, their ugly, blocky, cheap-looking appearance, and the fact that these really aren't appealing architectural contributions to this local area. It's also the excessive density of the flats, which doesn't feel appropriate for the site. There's also the intolerable loss of light for those living in the shadow of the towers, as has been mentioned. But I don't actually intend to sort of go into detail on those issues. The key ones that I would like to speak about are the material considerations relating to car parking, traffic, and the noise and pollution associated with traffic, and also a comment on strain on local amenities and services, although I will admit that I don't know if that's actually in scope for an inquiry of this nature. I strongly reject any suggestion that the position regarding parking and traffic as a result of the towers has been resolved. I will admit that I have been astonished to learn that the plans not only would add significant cars to busy local roads, but that more than this, there are actually plans to remove some of the existing car parking provision by the Travel Lodge on that first floor. This will, the towers will add significant new cars to busy local roads, and they will reduce already pressurised and much needed car parking. On the road that I live on, we already see the brunt of the effects of this. Due to these existing parking pressures, people park outside my home and down my road, all the way up to Elbar Avenue, looking for somewhere to park in order to be able to access Tolworth Broadway. This causes daily congestion on my road. Jams of traffic clogging the road, weaving around parked cars, beeping with frustration, and even dangerous driving. It really is an understatement to say that it worries me to consider how removing parking spaces and then adding nearly 500 new homes on that particular site will severely worsen the position, both in terms of parking and in terms of volumes of traffic. I have considered a lot in my thoughts on this, the nature of the site, hemmed in as it is by the boundaries of the A3, the large roundabout junction and the Broadway itself. This congests the immediate area in terms of the numbers of people and vehicles, and I do not accept that there will not be significant volumes of cars on the roads associated with the new towers. It was suggested earlier on in the session today by the appellant and I think also from the council representative as well, that the car parking issue will somehow be solved by mitigations of car club and a controlled parking zone. I reject that assertion. Car clubs have been around many years, and as far as I can see, they have not materially reduced vehicle ownership. A Centre for London report that was published last year found that 74% of households in Kingston own at least one car, with in the region of possibly 15% of those, perhaps more, perhaps a bit less, of those households are likely to possess 2 or more vehicles. The majority of these people who move into these towers cannot be expected to forego their vehicles for a car club. I just don't think that we can imagine that we live in a society where car use is not still dominant. So where are these hundreds of vehicles going to be parked? You know, I hear the comment on a controlled parking zone. I personally don't know the parameters of that. I don't know if local residents have been consulted, what you know, geography it will cover, and whether that really does actually solve the issue for both existing residents and indeed the residents of these new high-rise towers. And, you know, for me, that's also something, and this is a point I'll just come back to briefly in a moment. I think that's also something that changes the nature and characteristics of this local residential area. This is not a town or a city like Kingston, or indeed even, you know, the sort of nature of things near to Surbiton Station. And I don't think that's what people living here want. So I'd say please consider the impact here on local residents, but also people who aren't local but need to come to this area. For example, tradespeople and businesses who would be burdened by a controlled parking scheme and, you know, may not be able to carry out their services. So to the volume of cars, I mean, even if there were some way to adequately resolve parking, which I do not agree there is yet, where will the vehicles associated with those residents, the vehicles that are associated with increased activity at the Broadway be displaced to? So it was stated earlier that, you know, there's a desire that the development, the amenities and the plaza and so on would, to quote, give a strong boost to activity, So presumably that means it's hoped that increased numbers of people will be attracted to travel to the area to use those amenities and benefit from them in some way. And inevitably, in the society that we live in, that will also mean attracting cars, and those cars will need somewhere to park. So where will that happen? As I said, I am also very concerned about the volume of traffic from the through flow of traffic. So even if, you know, you do resolve parking, as I was saying, the volume of traffic will become oppressive. And it's very well evidenced the damage to mental and physical health and to the environment caused by traffic. So I'm not going to replicate that here, but, you know, that is known, particularly for traffic jams, which we will see so much more of if these towers and these nearly 500 new homes proceed in this way. Because as I said before, you know, this is such a hemmed-in site, it is going to be a really difficult proposition for local people. The last point that I wanted to cover was around going back to that thing about the nature of this local area and what people move here for, and also the impact on local services. So I've been a local resident for nearly 10 years, not nearly as long as some of the others who are going to speak today. But my strong understanding is that people live in this area and come to live in this area for the benefits of living in a more spacious, green, outer London environment and the sorts of characteristics that brings, which, you know, for me, that doesn't look like excessively dense high-rise buildings and overloaded streets. And as I say, the strain on vital public services and amenities. And those sorts of things feel to me much more akin to cities or large town centres than what people who would want to come and live in this immediate area would want to have. So as and when these towers become fully occupied, what is the plan for how schools, midwives, GPs and other services will manage? The British Medical Association has updated their published information even on Monday this week about unprecedented strains on GP practices. As far as I'm aware, there's no associated investment in infrastructure here. And in fact, I understand that's also the case with the development that's now underway behind the Hollywood Bowl, which I believe is in the region of closer to 1,000 new homes. So at what point does this get too much for local residents and for local services and people who run those? Surely that has to be a key condition. And for these reasons, I'd ask that the towers do not proceed. That's what I wanted to say today. Thank you.
Thank you, Ms. Simpson. Mr. Linus, Are there any questions you'd like to ask Ms Simpson at all?
Ma'am, no thank you. I anticipate that some of the discussion on parking and highways will come as part of the round table, but I have no questions for Ms Simpson. Thank you very much.
Okay, thank you. Thank you then, Ms Simpson. Thank you.
Thank you.
You're more than welcome to stay, but obviously please just leave when you need, because I know you do need to leave earlier. Okay, thank you very much. Can I bring in Mrs Walker, please, next? If that's acceptable, Mrs Walker?
It is, yes, it is. I am sort of ready. Okay. Good afternoon. Bridget Walker, 72, retired, lived on the Ewell Road since 1983, and following what Ada has just talked about, I absolutely know how the volume of traffic has changed in those 38 years. Since the introduction of the Go cycle and everything else that's happening around us, it is at unacceptable levels most of the time, and we have jams most days. Anyway, I'm not going to dwell on that because that was excellent. All right, so I'm sorry if my presentation is a bit disjointed, but I only found out this morning that what I produced was too long and you didn't want a repetition, so I spent the morning trying to rewrite it. So my pages look a lot, but I'm going to try and speak quickly. And the reason I did it again, I sent one in on Sunday, but I found that hundreds of documents had suddenly appeared on the website, and I did my best, got to read 1,000 pages, updated my assessment, sent it back in last night. So here we go. I've been actively involved in local planning for 28 years. Since 2015, 5 applications for the tower, but not one new flat has been built. In 2015, circa 25 people objected, and then 1,000 people signed a petition sent to the mayor. This time, 305 people bothered to write in, and we're upset over the scale and dominance of tall buildings in an area of mainly 2-3 story housing. Our residential amenity will be severely affected. As has just been said, Tolworth Tower is not situated in a major town centre like Kingston. It is not in an agreed opportunity area, and there's no mention of housing opportunity in the core strategy. Just go into the Adobe document, type find, you will not find it. The structural condition report states localised flooding, continuous water ingress, and expect the concrete to last 50 years if remedial works are done and if the defects are addressed. So who would buy a flat in a tower which may only last 50 years? Will the freehold be sold on, leaving leaseholders with high ongoing maintenance service charges? Think Grenfell fallout. They say the tower is unsuitable for 21st century offices, but it's okay to put people into rooms with low ceilings. This will be poor quality accommodation without private amenity space. Mr. Linus said there was a lack of demand for offices, so why has Lidl brought their headquarters of 750 staff to Tolworth, which is near enough opening now? With COVID, would it not be a good idea to use the tower for offices until the end of its shelf life, or demolish it now? On the 26th of November, Crossrail 2 has been cancelled or stopped by the government, yet this application still has it all over the pages as reasons for high density. All of the other applicants in the area have used Crossrail 2 as a reason for increasing the density. And it's not fair, it's not right for Tolworth to be stuck with higher density and no new trains. It just is not right. In 2015, C&M converted 78 service flats from the offices in the North Park Point. They rented them from 2019, they're about 1,500 a month. Now they're offering them for sale with a 990-year lease and allocated parking space. So I read from the condition that was set in 2016. It was approved that 54 car parking spaces to be used by residents for the proposed and shall be there forever. I can never say the word, but Judy. Now, the reason was to ensure the provision of adequate off-street parking accommodation and to avoid the congestion of surrounding roads by parked vehicles. So even in 2016, it was accepted that there was already congestion in this area. So surely you cannot ignore the condition just because the new scheme has a shortfall. In 2016, C&M had 370 units with 547 car parking spaces. Half the tower was going to be offices, half flats. and 203 in 4 new tower blocks. I maintain that the new 2 blocks are really 4, they're just joined together a bit cleverly. So at that time it was 220 hectares instead of the maximum at the time of 7170. I'm always being told this doesn't apply anymore, but it did apply in 2016. Now at the time they failed to inform the planning committee that they didn't own the Marks and Sparks car park, which they needed for the required amenity space. We told them customer lifts in Marks and Sparks didn't work. So how on earth as a customer was I going to take a trolley up the stairs to the 2nd floor? Because the lift just didn't work. And in the 2021 application, it's interesting to see that the unusable lift is to be removed. In November 2018, the Kingston Strategic Housing and Planning Committee resolved that the Tolworth area plan be deferred. So this draft, never adopted policy is still a draft. And yet the whole of this application is littered, whole diagrams printed from it as if it is fact and as a reason for 20-storey buildings. But the whole point that it was deferred, and I was at that meeting, was we didn't, and councillors, we did not want 20-storey buildings in Tolworth. Now 3 years have passed, it's still out of date, it needs rewriting, and I don't think it's fair, again, that we should be left with all the repercussions of that. Right. Okay, on to the current application. It's 499 units and only 134 parking spaces. But add on the 78 service departments and you have 577 for the whole site. So we maintain that that leaves you just 0.16 of a car parking space because of that condition. The densities on that seem to be 511, which is just massive for a PTAL 3. Where else is there in an area like Tolworth with this unacceptable high density? We don't have the infrastructure for up to 4,500 more people. Why should one 60s office block consign Tolworth to totally inappropriate high-rise dense blocks? Their definition states that it's in already a heavily urbanised area. Our character study calls it relatively low density, predominantly 2-storey housing, front and back gardens. Now, I personally have had a lot of argument with lots of people about site areas going right back to 2015. But what really upsets me is that so many applications have been approved on what I would call conflicting site areas. So 4.4 hectares was used to get 950 flats, which is really 250 more than should have been there, because the planning statements at 209 said it was 3.8 hectares. Now, what really hurts is seeing in 2021, the local plan site area, TH09, says it's 3.987. So not unlike what we were quoting back then. So what seems to have happened is as one gets agreed, the next person comes quoting that, and then they go back, and then all the time, the density is just increasing and increasing. And I don't think it's right. Now, much has been said on affordable housing, but there have been so many changes. Why should we believe anything they say? From 0 to 7 to 10ish to 14, and only if still approved. Either way, it's not 50%. And if you allow the SIL deduction, the community misses out on cash for project improvements, which they'll clearly need. Combining 2 to 3 bedroom, 2 and 3 bedroom as family units can't disguise the woeful provision of 6.8, or is it 7% now? The policy was written in Kingston because we've got a shortage, and it still has, because so few of the schemes provided recently have done the 3 bedroom as required. Okay, wind amenity play. Winds are stronger today. I mean, at the time of one of those assessments, we had 65-mile-an-hour winds. I had a lot of damage in my garden. So everybody knows the winds are getting stronger. Even with mitigation, this is the 71 blue dots on the standing position, whatever that means. It just means that there are still a lot of areas that are not suitable for amenity and play areas. If you now count the 78 flats are going to be sold, there's no amenity space there. There's no amenity private space for the 261. So overall, inappropriate, insufficient. Fire safety you're going to look at, but all I would say is converting an office block of 23 stories, which used to shut at 5 p.m. to 261 flats being used 24/7 with fridges, freezers, tumble dryers, cookers, needs to have the highest safety features to protect residents. I'm not sure that the disjointed fire strategy is sufficient, especially since Grenfell. The energy, again, I could not begin to read a 400-page document last night, but I did pick up on the electrical supply. And if they say there's no capacity, well, we will want to know what the potential demands of the development are for these 577 units, plus the 950 at Guinness, and whether there will be enough power going forward for even existing residents, as well as everybody having electric cars. So it seems to me quite crucial that somebody needs to talk to all of the electrical suppliers and the developers and really work out what can or cannot be supplied, because we must need some new substations, because we've had new substations on the Ewell Road for developments of 54. So, you know, that seems to be pretty crucial before you start building anything. Air quality, pollution, noise, water, it's unacceptable. We've been told to help improve fresh air circulation, we should keep windows open during winter to stop the spread of COVID. What happens when there are power cuts and the MVHR stops working? Do the windows open? I don't know. I just think it's unsuitable, as it will affect their amenity. I agree with Ada. Why would anybody who risks getting asthma want to live on one of the most heavily polluted roundabouts in London? It's an unacceptable air quality for more people. I also think there'll be more problems with the Victorian sewage water systems. In fact, not so long ago, there was a burst main just actually on the car park in Tolworth Tower, and it caused chaos. But I just put it practically. Office staff using the town 9 to 5 meant less sewerage than up to 577 flats, which may have 1,154 toilets in use. You know, I mean, I'm working on 2 a flat, but I don't know that. So it's just putting pressure onto the system, which will probably increase surface flooding, if nothing else. All right, now highway network and parking arrangements. I understand we're going to do it. There's going to be a meeting, but I'll try and do this quite quickly. It is a key thing. There's a severe lack of parking. TfL admit additional development will increase traffic on the Tolworth roundabout. Off-site parking has been reduced from new double lines as part of Go Cycle. In the case of where I live, that means 40 parking spaces have gone because we've now got double yellow lines, or will have when they finish my bit. I read yesterday that the rented flats had only used 20 to 30 spaces because they were able to offer short-term leases. But as they're now being advertised on Rightmove with allocated parking, with the build to rent model, we were told people wouldn't have cars, but with the build to buy, people will. So we don't believe that 0.16 of a car space would be justified or acceptable in the suburban area. Even if you use 0.6 space of the London plan, there should be 288, not 134. You also need to consider the cumulative effect of the under provision at the Guinness, because they're well under. And what about visitors? And as that's been mentioned, people who you want to go to retail, where are you going to park? We totally dispute the statement, there is no potential for highway safety to be impacted by overspill parking. Residents need an accurate assessment of existing parking demand. And I think that the statements that are there, they're not up to date. How can the appellant state that proposed development will reduce in all these reductions in car van movements when the architect's report says the tower has been fully vacant since the end of March 2019? So we've already expressed concern about existing traffic. So with a vacant building, you cannot demonstrate any reduction. It can only mean more. Any new development will increase traffic to go along with that from the Little 750 staff, Guinness 650. So there's a cumulative impact of overloaded highway. Right. Daylight, sunlight, I just think why should existing residents have to accept loss of residential amenity? Right. Now this is a key, this is one of the things that really, when I'm reading documents, I get cross with, because it's like everybody tries to skew the policies to their own advantage. Now, in this case, it really upsets me. In the updated planning statement of May 21, paragraph 752 they omit parts of policy T1 because they say there will be significant new housing development on the Tolworth Tower complex. It actually states there will be significant new housing development on the government offices, Toby Jug, Marshall House site, Tolworth Tower complex, and the Red Lion site. Now, since that was written in 2012, the build or consented applications comprises of 1,188 as against 600 planned in the core strategy. That's 78 service flats Tolworth, 54 on the Red Lion site, 106 Tolworth Girls and 950. So if you add that to the 499, you get 1,687, which is nearly 3 times the planned 600. Yet not one piece of new infrastructure has been provided. And without Crossrail 2 and the A3 roundabout improvements stalled until late 2020 because TfL have no money, it's madness to increase development here. A few comments on the design and access statements. 21, 27, 28 are misleading because the particular blue key was a key reason that the Tolworth area plan was deferred, as I said before. On the updated design and access at part 2.857, there's a diagram that to me shows red lines depicting incorrect heights. The old scheme was for 5, 12, 15 and 19. And I have got the map with me to show where it's wrong. Again, then there's a block diagrams that prove the first scheme should not have been consented and the new scheme's equally as bad. A particular annoyance on the design and access at part 3, 841, is where the appellant, the council all seem to think a loading bay in front of the Amina space is okay. It absolutely is not, because lorries and buses occupying one lane towards Tolworth roundabout will severely hold up the traffic. For the very reason when they introduced Go Cycle on the Greenway, they had parking bays there. They had to be removed and replaced with double yellow lines because they severely held up the traffic. It's madness. Plus, why would you sit in the pocket park and have all the big delivery lorries pumping out their fumes? It's just wrong. Now, I'm sure it's not part of a planning, whether you approve it or not, but it's architect proof of evidence 5.7. They show the key from the deferred document, but pages 30, 33 that have diagrams showing cars exiting from the M&S car park, which is wrong. At least I'm assuming it's wrong, because there's no way you can have where it is at the moment, you go in at the side and then again at the near the roundabout. So that is wrong. Okay. And on 11.4, they say the opportunity has been taken to reinstate public realm on Tolworth Broadway, which was lost when the land in front of Marks and Spencer was converted into a car park. Don't quite understand that statement, because 133 spaces were let to Kingston Council for 99 years from June 1959 to be used only as public car park. So car parking has been there since the tower was built. So do they mean they're going to take it away? And in which case we would not like that. So I'm sorry if it's been a bit rushed and all the rest of it, but the 160, there's one other point. It's not been mentioned anywhere, but to me, the waste management system is going to be unworkable. It's very complicated. It requires someone to move full bins from one floor to the loft basement, then replace with empty bins whilst keeping commercial bins separate from residential, and all the time bin lorries holding up the traffic, maybe. So that, I just don't understand why that seemed to be acceptable. In practice, I cannot see that working, not with 577 flats, plus Marks and Sparks, plus anything else that's built. So the tilted balance quoted never takes account of the prevailing character, and it does us such a disservice, unfortunately. The 160's ugly tower block built as government offices needs updating. They say it will cost too much to get it to today's standard, yet to put people in tiny flats with no windows. This overdevelopment will be a huge detriment to existing and future residents. Kingston was right to refuse it, and we really hope you will back Kingston and its residents. Thank you very much. That's it.
Thank you, Mrs. Walker, and thank you for taking us through. As I said, this is obviously your speech, yeah, but I've obviously got your main representation as well, so as well as other from everybody else.
Would you like me to type up what I've done today and send it in, because it is a bit different?
If that would be, yes, that would be useful, because that would be the actual speech, because I did see that there were a couple of bits that you added in that aren't in this, that aren't in this speech. So that would be really helpful if you could do that, because I don't want to miss anything that you've said.
Yeah, look, it's a bit of a mess, so yes.
So I would appreciate that, but obviously we've got this version and your main representations anyway. So thank you for that. Mr. Linus, any questions that you'd like to ask Mrs. Walker at all? Mr. Linus?
Ma'am, no thank you. There may be a couple of points I'll pick up with my own witnesses in due course, but hello, can you hear me okay?
Yes, we can, yes.
Hello? Can you hear me okay, ma'am?
We can see you. I'm not sure if you can see and hear us. Is anybody else present? Is anybody else present from the appellants? Ooh, that was good feedback. I was just going to say, we can see you and hear you fine, Mr. Linus.
Ma'am, I've turned into Heather for a couple of minutes. I have no questions. I told there may be a few points that I want to pick up with my own witnesses, but I don't need to ask any questions. Thank you very much.
Okay, thank you. Thank you, Mr. Linus. Okay, can I bring in now Councillor Holt, please? Thank you, Mrs. Walker. Councillor Holt, please.
Thank you very much, and I'd like to thank Bridget and Ada for coming along and giving such good representations for the residents in the area. They've covered quite a lot of topics, particularly Bridget has covered quite a lot of areas that I will be sort of duplicating, but I'm not going to. I'm just going to continue in a probably a little bit more concise way. But I think she did make points in quite good detail, and it's good that you will take that away and reflect on that.
Thank you.
So for me, I'm probably having made a few amendments to mine as I've gone along, just because of some of the other representations that have been made this morning, but it's only small things. Do you want me to amend my document and to send it to you as well? Would that help?
If it's only a few points here and there, as long as you give us time to write them down. I just don't want to miss anything that's not in writing. So if it's only a couple of points, just give me time to write it and it should be fine. But if you want to send an amended version in, you're more than welcome to.
That's fine. It's just that we're reading from a statement, so therefore it's, you know, you might do slight adds as you go along. But okay. That's great. Thank you. So thank you anyway for I've already introduced myself, but I'm Councillor Holt and I represent Surbiton Hill Ward, and I'm also chair of Surbiton Neighbourhood. I've lived in Surbiton Hill Ward for over 10 years, and I've lived in the borough for over 20 years. So I've a lot of experience of seeing and going past Tolworth Towers. The application itself was not, was actually, we brought it to Surbiton neighbourhood because it is in our neighbourhood. It was consulted on, where residents could come along with a little bit more time to make their comments, which a lot of them did, and also the councillors and the appellant came along and did speak to the people who were at the committee meeting and answered questions. So that was good that they did that. But the outcome of that was that the committee felt that I should write to the chair of planning committee and the head of development management outlining our concerns, because they felt quite strongly about some aspects. So I'm not against development, or for that matter tall buildings, but do feel that they should complement the area in which they sit. As with any design, it is a personal matter, whether you like something or not. I've always liked Tolworth Tower. It is, to me, a fine example of a 1960s building with some key features, which I think they could have maybe made more of in the plans, particularly the side spine. And it is a landmark in the area. It is, however, looking a bit tired, which is why I'm not against improvements and further development, which is sympathetic to the area. and takes into consideration the impact on the public realm. Previously, Meadow Partners attended Surbiton neighbourhood to outline their plans which was well received as it was refurbishing the existing tower, had 35% affordable housing within it, and the tenure was rental, along with retaining some office space. The amended application is for the 3 towers containing 499 dwellings, and mostly 1 and 2 bedroom flats. There are 6, I think currently we're sitting at 6.8% as 3-bed units, which falls way below the 30% required by the council, and something that we would be looking at in the applications that come to Surbiton neighbourhood. The initial application had no affordable housing, which goes against the council's policy of 50% affordable, and also the London Mayor's policy on affordable housing. However, I am aware that this has now moved, and heard this morning that it's to somewhere around about 10%, but perhaps about 50 units, which is something, but is still very well short of what we would like and what we think we need for the area. I do recognise that developers need to make a profit, but we also need to ensure that we have a good mix of housing. We need affordable housing that's not just 80% of market value, but shared ownership and London living rent. This would make the flats more affordable, particularly to those entering the market who are finding it difficult to get onto the property ladder, and for those who are not able to purchase and need to rent. The plans do not have a great deal of amenity space or connect well to the existing Broadway. If we are to have tall buildings, then the infrastructure needs to work harder to accommodate this. A pocket plaza, which is likely to be a wind tunnel, and I realise there are some information will come on this, is just not going to be enough. And also, we've made touched on the lack of commercial space, or the loss of some commercial space and office space. The greenway in the centre of the Broadway was initially intended to link Alexandra Recreation Ground to Tolworth Court Farm, green spaces which future residents of this site are likely to use, along with, Bridget mentioned, a number of the other developments that are in the area, so it wouldn't just be servicing this site. Whilst both these green spaces are close by, it's not easy to navigate, particularly for families with young children, and there's no play parks within this current this site at the moment. There was an opportunity for the plans to incorporate and enhance this. I visited yesterday, which is my bit I'll add, the main bit I'll add. I visited Woodbury Wetlands in Hackney yesterday because we wanted to see for another potential situation in the borough, and saw how a good development can incorporate mixed housing, variable heights, and what I consider to be fabulous open spaces, including a wetland, so for use for all. The plans do not give net zero carbon, which isn't quite important to us, to myself as a councillor, and to I think my fellow councillors in Surbiton neighbourhood, and is required under the London plan. The area has high pollution levels due to the proximity to the A3, and I would like to see more. So generally, we've talked a little bit about the energy that needs to be, the energy information that's come forward that needs to be looked at. But for me, there needed to be more generation of the energy on site, cooling as well as heating and insulation. And I have also seen in other boroughs where they've made the use of city trees to absorb pollution. So as already mentioned, it's a shame that this has not been considered early enough. So we're getting these documents late, and the late material we'll have to, certainly I haven't had a look at myself. In conclusion, I am not against the development, against some form of development, but sadly this application does not meet the affordable housing criteria for either the council or the London Mayor. It does not have enough quality amenity space within the site and could do more to integrate with the surrounding public realm. Thank you.
Thank you, Councillor Holt. Mr. Linus, again, ask any questions.
No. No questions. Thank you very much, ma'am.
Okay, thank you very much. Thank you very much, Councillor Holt. Now, I would like to just ask the two main parties for, I'm considering swapping around and moving straight on to the roundtable discussions, particularly in relation to the car parking, as we have the interested parties present who may wish to be involved in those discussions, and then moving on to fire safety, and then doing the design presentation. It's just a thought so that some of the interested parties don't have to, if they need to go, then they can. So any particular issues or concerns with that from either main party?
Not from our part, ma'am.
Okay.
No. Seems sensible, ma'am.
Mr. Burton, okay. So if we can go straight into the roundtable session then on the car parking and highway safety, please. And what I would like to understand, obviously the council or both main parties have made it now clear that from your perspectives, the issues around the council's reason for refusal has now been resolved. That's my understanding. I'll go to Mr. Burton first, because obviously this was a reason for refusal that was put in. So that has now all been resolved from the information that I've read, and obviously you've set that out quite clearly in the statement of common ground and in your opening.
Yes, madam, that's correct. If it assists members of the public, just to give them the potted summary, the council was concerned that it didn't have any information about the extent to which the so-called North Point parking spaces were actually being used by North Point residents, occupiers. So it didn't see how it could actually reach a view sensibly about whether they could be released based on mitigation being offered or proposed, or indeed reach a view on the mitigation required if they were to be released, because that's one of the things that's happening. Of course, it's not all of them are being released, but the majority of them are being released, and the total car parking is reducing on site. The appellant, after the council's statement of case, provided evidence about usage, which had been missing previously, and also met the council's requirements as regards mitigation through the section 106 for essentially parking and traffic matters. So that's in a nutshell where we are, and that's why the council is now satisfied on that reason for refusal.
Thank you for that. Can I ask if anybody, any of the interested parties present, is there anything further you want to say about car parking and highway safety? Obviously, you've all mentioned it as part of your speeches and what you've told me this afternoon. But is there anything further that you would like to highlight? Ms. Simpson.
If I may, and I do so apologise that I need to leave in just about 10 minutes. Well, I did want to say, you can look at all of the numbers that you like. It doesn't change the facts of how it feels to live here and the burdens of parking and traffic on us. And I am surprised about why the council think that these mitigations work. I admit I don't know all of the detail of the proposals, but I believe I know enough to know that they aren't going to solve the issues that myself and other local residents have to live with, and how very damaging that is. And as I mentioned before, I do think we need to take in special consideration the particular site we're talking about that is so hemmed in. It is a really difficult position. And as other parties have also mentioned, the other developments going on just the other side of the roundabout that add to all of this. And I think it would be, in my view, irresponsible to consider these things in complete isolation to one another. So I realise that's not anything new, but I just want to say, the strengths of feeling of how this actually feels if you are faced with this.
Right. Sorry, is that Mrs. Walker?
Yes, yeah.
Anything you want to add?
Yeah, it's just being thrown because I wasn't expecting all this, but I've just gone from an earlier one that was submitted as part of an application, one of them, and I'll read it. RB Core Strategy Policy DM10 requires development proposals to have regard to local traffic conditions and highway safety and ensure they're not adversely affected. We cannot believe any transport assessments which use out-of-date 2011 method of travel to work sensors. In then it was nearly 2019, now it's 2021, and it's an insult to residents who face daily problems with traffic congestion to even consider this data and to apply out-of-date sensors to a full building which has been, well, as we know, empty since 2009 is rubbish. We've never really believed anything TfL have said when they say if there's no impact, because this is their statement. The surrounding highway network often suffers from unacceptable levels of congestion. The A3 Tolworth interchange suffers from significant congestion in peak periods, both during the week and at weekends. TfL is therefore concerned with any development that will generate additional traffic and the potential congestion and safety that will cause. So any additional travel will add to the daily. Now, in view of that, with Lidl and the 950, they had to cough up 2.5 million or something like that for what I can only describe as a left turn somewhere on the roundabout. And that is not going to start until the end of 2022 because TfL haven't got any money. Now, 15 years ago, when the Tesco site, which is now Guinness, we sat at focus groups. The transport experts, they gave us 6 plans. They said, what do you think will work? And we said, well, will any of them work? And they said, not really, because the volume of traffic won't make any difference to what we do. And that's it exactly. The volume of traffic. Last week, there was a crash on the roundabout. And I was waiting for a bus because I don't drive, so I need buses. And it just, you know, the 281 couldn't get round because it was stuck on the roundabout. The 400s coming from Epsom, well, no chance. They were like 40 minutes. So it doesn't take much on that roundabout to stop it. What they're doing with Go Cycle is just, it's a 4-lane road, the Yule Road, it's an A road. It has reduced it to 1 lane either side, basically. And it's not finished yet, and it's just awful. So we're already going to have the problems from that, the parking that it's taken away. I can't show you photographs today, but every single road near me is at capacity. There's so much development going on. There's builders' lorries here, there, and everywhere. It's been like that for years. Some of the roads have introduced themselves a seat of controlled parking, but at those meetings, you pay all that money, but it doesn't guarantee you having a space outside your house. So if you do that at Tolworth Tower, there's the Sunray estate, there's the Guinness. Who gets the parking space? You know, if you pay, there aren't going to be enough spaces, even if you introduce that. So where are the cars? What they're going to do is they'll just go round and round. So at the time in 2019, on-site parking service would show what was available because it was an empty office. And the flats were advertised and not rented. So, right, we said all that. Yeah, just because the London Mayor wants everybody to cycle, in reality, that's not going to happen yet, surely not in my lifetime. So I just think that it just makes no sense to say we can have 577 units and only 134 car parking spaces. I think with the 950, there's only 300. So that's an awful lot. Most people have 2 cars. You know, along the road where I live, they've got 3. So we're in houses, but people in flats may have more than 1, or they may have none. But the original conversion of the tower was we've got this build to rent, and we were told by TfL, by everybody, people who come in build to rent, they won't have a car. But now it's build to buy. So it is a difference. People who buy flats will want one. And one of the reasons with Crossrail 2 not coming, in this area, you can either get a train into Waterloo, into Victoria, but if you want to go somewhere else, you need a car. There's no transport across public. And that's why I feel so strongly that I can't understand the council saying, and the traffic engineer saying it's okay, because it is not okay. It's very unfair to existing residents who already suffer, and then the new residents who, well, you know, it's just going to be ridiculous. I can't really say any more than that. I hope I've made it clear enough.
You have. Thank you, Mrs. Walker. That's really, really helpful. Can I just ask, I don't know if the appellant wants to come on this, or whether the council's now in agreement. Can you just explain how the measures that are proposed, particularly, I think the interested parties, I don't know if it was Ms. Simpson or has raised the issue about if there's a controlled parking zone, what would be the impact on local businesses, etc. Because if people are coming to this, my understanding is that Tolworth Broadway, because of the range of shops on there, from what I've read, it is a form of destination shopping for certain goods, for instance. And therefore people travel into the area to go to Tolworth Broadway and the retail shops there. How does a controlled parking zone work in that respect in relation to visitors coming in and the on-street parking and so forth? I just want to understand that, or does it not impact on that?
Thank you, ma'am. May I introduce Mr. Bush, who was on the list of witnesses I gave you earlier?
He was, yes.
And he prepared the transport statement, which you should have, as well as the transport impact assessment for the scheme. Perhaps I can ask him to deal with that question, if I may.
Thank you. Thank you, Mr. Bush.
Yeah, hi there. Lloyd Bush. I'm a director at Velocity Transport Planning. In terms of the controlled parking zone and accommodating other demands as well as residential parking demand, the CPZ doesn't just deal with residents' parking bays. It can deal with all sorts of other types of controls, including limited waiting or pay and display bays within it. So ultimately, it comes down to the design and accommodating the demands and the needs that are required of those sort of retail units and the high street itself. But it certainly wouldn't prevent any sort of controls to deal with that. It would still mean that you'd have parking bays that could be accessible by residents of the wider area visiting the centre, as well as loading bays, anything else for servicing, but also that restrict the ability of the new residents from permanently parking within those locations.
I mean, when I walked up and down Tolworth Broadway, I did notice there were some existing sort of bay areas where it is pay and display. If you're just talking about just Tolworth Broadway, but obviously immediately off those you've got residential streets, which obviously the interested parties that I've listened to this afternoon are concerned about. And are those the sorts of areas that are being considered as in terms of controlled parking zones? Just so I've got a better understanding of exactly what is potentially proposed.
Yes, that's correct. So the area review it isn't defined as such, but would be defined by Kingston. But certainly the residential streets, we would be looking more at residents parking controls that would enable residents to park within designated bays, as well as visitors via visitor permit schemes that exist within CPZs.
So who parks there now? Has a survey, or obviously when I walked around, I saw I saw what I saw at the time of my visit, and I saw a lot of parking along the residential streets. So are those existing residents, or are those workers, or are those visitors or shoppers, or has a comprehensive survey been done?
So a survey has been done. There was an overnight parking survey as well as daytime parking survey undertaken to determine the occupancy of the streets in the surrounding area. What's not possible to do within those is identify whose his residents' cars, whose his employees' cars, etc. The mix, because obviously we don't know specifically vehicles who they relate to. It just looks at the capacity, but there is potentially a mix at the moment. There may be people who also travel there as commuters who park and leave their car and go to the station. There's various reasons why at the moment, because it's uncontrolled, that there might be more demand than there might need to be. And typically in implementing a CPZ, it gives you the opportunity to discourage unnecessary parking behaviour that might already be causing some stress to residents in terms of the parking demand that's there.
I'm not sure if this is a question for yourself or maybe for somebody else, but I noticed that the car park for the station is relatively small. I mean, at the time when I visited there were spaces. But is it anticipated that additional travel will be done by train? Although I understand that services won't be changing as part of this. Is that sort of has that been taken on board? And then whether additional parking or not is required at the station or in that vicinity, or is that being looked at as part of a different development?
We wouldn't anticipate that anyone from our development who owns a car and has a car parking space would look to drive to the station. We would anticipate that they would undertake that movement on foot or even potentially by cycle if they wanted to cycle on their onward journey from the train. So as part of this development proposal, we wouldn't see any requirement to increase station car parking. And again, generally speaking, as a wider principle, I wouldn't suggest that was necessarily an appropriate proposal, because it would just encourage people to use their car to travel to the station rather than by more sustainable means.
Thank you. No, I certainly wasn't suggesting that there was a need for car parking for the for this proposal for the train station, because it certainly close in terms of walking to get there. I'm just trying to understand the locality of what's been looked at in terms of the implications of, because what I've heard from interested parties is that there's accumulation. So it's the cumulative effect of different developments and what implications that may have on existing car parking areas within the vicinity. And obviously the train station car park is actually quite close to Tolworth Broadway. It's not actually that far to walk. And whether there would be implications for not saying that the development would need to provide any parking at the station. That is obviously not the case, but I'm trying to just understand what the implications are for any controlled parking zones and how it would impact on the transport usage within the locality.
Yeah,
if all these measures are coming into place.
Much of that comes down to the consultation and then the subsequent design of the CPZ in terms of what ultimately the local authority seeks to accommodate within that. So historically, I've done work for outside of London, Epping Forest and Essex County Council implementing controlled parking zones on the end of the sort of central line in relation to sort of Epping Station, Buckhurst Hill Station, and those implementations are focused on discouraging commuter parking to prevent people from travelling to those stations to park and go to work, but to find alternative means or to travel from a station that is actually closer to them rather than one that's closer in and cheaper because it passes a zone. So it does depend on the design of the CPZ and ultimately what the local authority looks to accommodate within it.
I think just one sort of final question from my perspective, and again, just to clarify a point that I think Mrs. Walker raised about how long has the tower been vacant in terms of office use? I'm not necessarily aiming that at Mr. Bush, he probably doesn't know, but how long has that been vacant?
Ma'am, I'm just being given some instructions here. 2 years, as I understand it.
So, Mrs. Walker, I think you raised, and please tell me if I've got this wrong. I may have noted it down wrong. But didn't you raise an issue about some of the surveys have been done when the offices have been vacant? Was that one of the points that you made?
Without finding it, one of my questions from the transport gentleman was, when was that survey done? Because I haven't gone back all over the transport, bearing in mind where this has been going on time. So my point was, they were in the latest one that appeared this week. They are appearing to say that there are like 142 movements, this and less.
So is your point is that's because the offices are empty?
So they can't say, if the offices have been empty for 2 years, they can't be saying this will be reduced because it's been empty. So if we're saying as residents, and they in their comments from residents, they were saying, we're all saying we already suffer from existing problems. Their argument that there will be less coming out of the tower is irrelevant because it's empty for 2 years. So what's happening now? That's what I'm saying. When were these surveys done? I mean, can I just take you very quickly back? Last March at lockdown, there was not a car on the Yule Road. It was heaven. No longer did I get black dust on my windowsills. It's gradually coming back to normal. So all of this, whatever transport has been done, it's irrelevant because of COVID, because it has to be done again. It really has to take account of what's happening now. And I can assure you that loads of people are working from home in this area. As for commuting traffic leaving their cars, it doesn't happen at Tolworth. They leave it near Oak Hill, which is just next to Surbiton Station. The other thing that needs to be brought into mind is that the station only has 2 trains an hour and no Crossrail. Lidl are providing a coach for their staff from their new offices in Tolworth to get to and from Surbiton Station. Now, Surbiton Station is actually at capacity if you had full commuters. It's horrendous getting up and down the stairs. So that's another point. And yeah, so really, my point, we need some up-to-date surveys in the interest of what is happening now. You must, each day is going to be different, but it depends on when the surveys are done. Is that the day somebody goes to work or works from home? All right, it's a changing scenario from what it was with all of these applications for the tower. And I really think it's a disservice to the residents to go back to the CPD. There's a few roads near me. One road, they had the consultation, they agreed. And I remember them saying, it doesn't guarantee you a space outside your house. Then the next road, because once they'd got the control, the next road then got more of the traffic from the overspill. But they decided they didn't want it, they'd manage it. And you just push it from one area to another. And that, when we were at the appeal for the Guinness, which was mayor, we went round the Sunray estate to see how much available space. And people from there have said, if the tower gets implemented with this lack of parking, people who have a car will go over to the Sunray estate and take the residents' parking. It's a knock-on effect all the way around. And it's just wrong to just pretend that you can get away with no parking at the moment. Maybe in 10 years' time, there will be no petrol, there will be no electricity, and everybody will be walking and going by car. But we don't know that now. So we have to look at the current scenario and where you can actually put a car. I would say there's too many houses, so therefore you wouldn't need as many car parkings, too many flats. So there's you're saying, cut down the number of flats, use your 134 spaces. That's one solution.
Thank you, Mrs. Walker. Is there anything further that the interested parties present? 'Cause I think Ms. Simpson's now left. So, Councillor Holt, anything further you want to add on this particular topic that we're dealing with?
I just wanted, I mean, I presume there's a lot of people in this meeting know that, the council will have to do the CPZ process, will have to do the consultation and pay for the works to do with it, the installation of it. So, and that has to be agreed. I mean, we would have to go out to consultation to the residents nearby. So I just wanted to be clear. These are the side roads that currently people are probably experiencing, depending on what end of the road they're on, will be some of them will be experiencing quite a bit of disruption if they're nearer to the Tolworth Tower end, but maybe towards the other parts they're not interested in it. So it's a complicated process. So I just wanted to clarify it and to add to what Bridget had said about the CPZ process.
Thank you. Thank you. Is there anything further that the appellants or the council would like to respond on any of the points that have been made?
Yeah, can I make just a couple of points, I suppose? Just in terms of the way we've looked at the development on the other side of the roundabout, and I suppose to some extent the Lidl headquarters development, that was very much about trying to restrict the amount of parking to reduce the amount of traffic, and the £5 million was to improve the roundabout so that we didn't make that situation any worse. We sort of brought it back to the level it would be before those developments. And I suppose in a sustainable location like here, then we would expect limited parking, and that people would be able to live here with the access to facilities and public transport in this location. And yes, it only probably does work with the implementation of controlled parking zones, but that's not unusual in the borough, and those do happen. So I suppose that's how we've come to the conclusion that the amount of parking is acceptable and meets the London Plan standard.
Thank you.
And Ma'am, I'm happy to just add a tiny bit more. Obviously, one of the questions was about the parking surveys, which were undertaken at a point in time when there was some occupation of the office. So would have picked up some of the demand at that time, which we understood was in the region of sort of 20 to 30% occupation. That was undertaken in March 2018, and we did, through the sort of pre-application discussions with the local authority, discuss parking surveys and the need to look at any newer parking surveys, but due to COVID and the changes in behaviour, it wasn't deemed appropriate to do that at that time, and in particular because of the surveys that we undertook were both daytime and overnight. The overnight parking surveys were not considered to be particularly affected by any other changes that might come forward more recently, and they did demonstrate that there was capacity within the area. So it's within section 6 of our submitted transport assessment. It actually demonstrated that there was about 63% occupancy of the available parking overnight, which is normally taken to be the time that you can identify residual residential demand, by comparison to during the day when that increased to about 84%. And also, just to touch on the councillor's point of the implementation of the CPZ, that it obviously will ultimately sit with the local authority in terms of the consultation process and implementation design of that. And it will be an area wide. So as you say, there will be considerations about the extent of that, any impacts of the CPZ that goes through that process. But from our side, we've brought forward the proposal in accordance with policy T6 Part C of the London Plan, which basically says that in an absence of local parking control shouldn't be a barrier to new development, and the borough should look to implement these controls wherever necessary to allow residents to maintain safe and efficient use of their streets. And they're the discussions that we've obviously been having with council, and why they're satisfied that the proposal we brought forward is appropriate.
Thank you, Mr. Bush. I'm going to propose to move on. So unless there is anything for Mrs. Walker, you've got your hand up.
one last point now that he's said. If that survey was done in 2008, it's exactly my point. That's 3 years ago. The world has changed. It's not accurate. It's not up to date. And it needs to be done again. And I completely disagree with our council that it's okay. It is not okay. You might want to restrict people parking, but the reality is the cars are there. They're there now and they'll be even worse. Thank you.
Thank you, Mrs. Walker. Is there anything further that anybody wants to refer to in relation to parking and highway safety?
No, thank you.
No. Okay. Thank you. Can I move on to the roundtable session on the fire safety standards, please? Fire safety elements.
I'll just ask Mr. Marshall to join us, if that's okay.
That's great. Thank you.
Yeah. Mr. Bush will obviously disappear from your screen shortly.
That's fine. Thank you. Thank you very much. So I suppose what I would like to, because I realised that I've been sent something this morning, which I haven't had had a chance to have a look at in great detail. But there is further detail has been sent on the current progress of the Statement of Common Ground. So the email sets out the Statement of Common Ground. Now, unfortunately, I've not been able to look at it because I only received it this morning, literally half an hour before we would start. So I haven't had a chance to have a look at it. So it may be more useful, I think, in terms of this time period to just, if both main parties can just set out your positions so that I understand what's the stumbling block, if I can put it in that way. What's the key issue here? So if the appellant, if you would like to
Okay, ma'am. I mean, I think the first point is to say that I don't think there's actually a what you would call a stumbling block. In this case, perhaps I can just summarize where we are. The chronology of the discussions on this issue are set out in the Statement of Common Ground, which I don't need to go through now. You can read that outside this inquiry time, ma'am, in due course. But where we ended up with the GLA was that there were 3 outstanding issues raised towards the end of September. One was the alleged absence of a single statement on fire strategy. 2 was the absence of effectively an independent certified assessor to confirm what the contents of the fire statement were going to be. And the 3rd was an issue in relation to evacuation lift provision. Now, I can ask Mr. Marshall to explain this, but in short, you will have seen from his fire statement that he did prepare a single fire strategy, which was appended to that document. And our position is that that has obviously addressed a concern that had been raised by the GLA on that matter. Secondly, Mr. Marshall is the independent certified assessor, and therefore that issue has been addressed as well, and we can confirm that to you this afternoon. As for the evacuation lift strategy, this is where further discussions have taken place between ourselves and the council, because the GLA had raised certain concerns as to whether or not we demonstrated adequate evacuation lift provision. And there is an email which you will not have seen yet from yesterday afternoon, which I understand will be one of the appendices to the travelling draft of the Statement of Common Ground, where we explain the guidance as it currently stands, draft British Standards guidance on the provision of evacuation lifts. And we explain how within the scheme, it will actually be possible to go beyond what the GLA appeared to be suggesting was required as far as evacuation lift provision is concerned. I can ask Mr. Marshall and possibly Mr. Taylor, if necessary, to explain how that operates. But in short, our position is that we comply with policy as far as evacuation lifts are concerned. That's the short summary. I can ask Mr. Marshall to explain how the lifts would be used to evacuate Tower 1, which is the issue that's been raised by the GLA. But before I do so, perhaps it might be useful just to hear what the council's position is, ma'am.
Mr. Burton, please. Thank you, Mr. Linus.
Thank you, Madam. Well, I'm going to defer to Mr. Feltham on this because he's been dealing with this.
Thank you, Mr. Feltham.
Okay, yeah. So I think the one issue really is in terms of, it's a practical issue really, of how many lifts will be required to get people down in the event of a fire. So I think it may be only one that's required, and it's understanding that can be provided. I think the latest issue really comes down to some of the lifts that could be used for this only call at certain floors. So if we're able to get sufficient lifts, and this is subject to imposing two conditions, one about the fire statement, one about the fire evacuation strategy, which, because it's a condition, we don't yet know what the answer is in terms of how many will be required. If we can resolve that, then this should be okay. But at the moment, we don't know how many lifts could be used for this and whether they would call at all of the floors. And I think that's the sort of last sort of outstanding issue, which was raised in discussion with the GLA, I think only yesterday, if I remember rightly.
Thank you, Mr. Felton.
Ma'am, perhaps then would it help if I ask Mr. Marshall just to explain the position as far as evacuation lift provision is concerned? I can ask him to essentially summarise what was contained in the email explaining lift provision, and you can read that in due course, ma'am.
That'd be really helpful. Thank you, Mr. Marshall.
Right. So I guess essentially the main kind of code of practice for fire safety design in residential buildings is British Standard BS 9991. There's currently a draft of development that's sort of been circulated, which is including an update that includes evacuation lifts within buildings. And that kind of suggests that it's acceptable to use a firefighting lift and an evacuation lift where you've got a staple strategy. So in essence, that involves each flat being a compartment. It's got its own standalone fire detection system with no kind of external link to any other fire detection system. So in essence, we're only expecting one flat to be evacuated at any one time. And therefore, the evacuation lift requirement is quite sort of low in terms of the burden, because you're not talking about a lot of people at any one time. And this is sort of recognised in the updated guidance, which sort of suggests you can use the firefighting lift as well as an actual evacuation lift, as a sort of single lift for covering dual purposes. So in essence, in addition to that, we've got further 3 lifts. Of lift 1 serves all floors, and what we're suggesting is that lift 2 and lift 4, whilst they don't serve the full floors, they do individually serve each other at level. So in essence, from every floor level, you've got 2 evacuation lifts available, with guidance sort of suggesting in BS 9991 that the reason for sort of needing more than 1 lift in high-rise buildings is that if one's not available for servicing or if it's broken down, then you do have that redundancy available in the sort of 2 lift provision. So I guess that's kind of in summary how we've assessed and consider it meets the guidance.
Ma'am, if I could just add, the position where you have one lift which serves every single floor is the starting point. As for the other 2 lifts Mr. Marshall mentioned, it's actually an improvement on the position of having simply one other lift that would serve all floors, because if one serves the top half of the building, to put it crudely, and one serves the bottom half of the building, there's potentially less waiting time for anyone who's wanting to get out, either if you're in the top half or the bottom half, because you've got discrete lifts serving discrete parts of the building. The other point I would make is that, as you'll see in the email, there are actually 4 lifts within the Tower 1, and if it were necessary, the 4th passenger lift, which also serves the lower part of the building, where more of the disabled units are intended to be placed, that could also be brought into action as an additional lift. So whether one's looking at the shared firefighting and evacuation lifts, or one's looking at discrete firefighting and evacuation lifts, one can provide a minimum of 1 discrete evacuation lift and potentially more. So on that basis, we think that we'd be complying with the draft guidance as a minimum that Mr. Marshall mentioned, but we could go further than that if it was thought necessary. I think that brings us back to Mr. Felton's point that we understand that the council would seek to resolve this through the use of conditions which confirm the position, and we don't have any in principle objection to achieving that.
Thank you. Yes, I've got the plans up, which are in Mr. Marshall's proof. So I'm just looking at those.
Yes, ma'am. I think it may be better. I don't know if you have access to it, but there is probably a better image which is included in one of the emails that should be appended to the travelling draft of the Statement of Common Ground. I don't know what form exactly that has been passed on to you, but there is an email which is dated the 11th of October, which should have a plan of the proposed lift provision in Tower 1 within it.
So I'm just having a look, because I do have an email with lots of emails on it. Oh, here we go. It's probably that one. Right, yeah. Okay. I think I've got the one up that you're referring to.
Right. Can I just check, ma'am, so we're not talking at cross purposes? And is that an email which starts Dear LPA with a couple of paragraphs of text? Thank you very much.
It is.
Well, I think as Mr. Marshall summarised, his starting point was that the draft British standard guidance at the moment suggests that you can use firefighting lifts for the purpose of evacuation, but even in the event that one wants to move beyond that and have discrete provision, if you look down further on that email, lift 1, if that were identified as a firefighting or passenger lift, one has lift 2, which serves levels 12 to 22 and then goes down to the ground floor. Then you have lift 3, which serves levels 2 to 12, goes to the ground floor, and lift 4 serves levels 2 to 12 and goes to the ground floor. And now the point that we've been making is that for those on the upper levels, they would have access to 2 lifts. One would be lift 1 on the basis that was a shared firefighting evacuation lift. In the event that that were not shared, there would still be lift 2, which could serve the top half of Tower 1. That's the top half of the building. As for the bottom half of the building, again, lift 1 could be used to be shared as a firefighting lift and evacuation lift. If that weren't the case and you were dedicating lift 1 to a firefighting lift, you'd have lift 3 that could serve the bottom half of the building. And if that were deemed for whatever reason to be insufficient. We don't think it's necessary, but lift 4 could also be brought into action as well. And the email goes on to suggest that 18 of the 26 apartments in the building have been designed to meet M43 standards, in other words, to allow for wheelchair access, are located on or below the 12th floor level. So potentially, we don't think it's necessary, but potentially they could be served by lifts 1, 3, and 4. And on that basis, we say that there's more than adequate lift provision within the building. And as I say, we're content for those matters to be brought within a condition that then has to be approved by the council under the planning permission.
Thank you. That's been useful to just run through the latest information.
Just in relation to that, well, I think we were waiting from the appellant to get some additional information following our queries yesterday to look at this lift issue. I don't think we've yet received that. So
what information was that?
Well, it was because this issue around the lift, it was raised at by the GLA to me towards the end of yesterday, and raising the concerns about we're still not sure how many lifts will be required and whether it will serve all of the floors. And obviously the other issue to bear in mind is that people may convert their units into, for disabled purposes that aren't currently for disabled purposes. So they would all be convertible. So we can't just exclude certain floors. I know we're not completely excluding them, but so when it was left to me was, well, we were still waiting for some more information to just sort of finally clarify that point so that we could be satisfied. And I suppose the real thing that we're concerned about is that if we can't provide it within the current lifts, well, then there are going to have to be some alterations made to the building, which would affect the overall layout of the building. So that's, I suppose, the bit that we still haven't got full comfort on.
Mr. Linus,
help there, ma'am, and we're not entirely sure what further information is required. I mean, as we understand it, the council had said they were entirely happy with the approach to lifts until the GLA email came in yesterday. The GLA email, as I understand it, made some assumptions about what lifts would serve which floors. It wasn't entirely correct. And the correct position is, as we have indicated, as for the point that Mr. Felton raised about flats being converted, that just isn't an issue, because for reasons that I've given already, even if one's looking at flats in the upper part of the building, there is a separate evacuation lift provided in accordance with policy. And there could be two if, as Mr. Morris explains, it's justified to have shared firefighting and evacuation lifts serving the upper stories of the building. So we don't think that the potential for conversion is an issue, because we've covered that as part of the provision. And we don't think there's any need for the proposals or the plans to change, because, as we've indicated, we think we can achieve proper provision within the scope of the plans as submitted. So we just don't think there's any feasible prospect of us having to change what is in the buildings, because in T1 rather, because we've explained what the position is with the current lift shaft. So the information that we provided yesterday has explained what could be provided, and we're not entirely clear what further information the council is seeking from us in circumstances where it's already accepted previously that a condition could cover this issue.
Mr. Felton?
Yes. So I'm looking at an email sent to me at 17:52 yesterday, saying from Pete Tanner saying we're reviewing now along with your previous fire email and we'll come back to you. So that was in relation to the email sent by Valeria Cabrera of the GLA at 17:08 yesterday to raise this issue about the lifts and her. And I think the particular issue was about the number of floors that the lifts stopped at. So, and I don't think we've had anything to respond to that, to give us that comfort.
Is this something that is so I'm looking at yourself, Mr. Linus. Is this something that the appellant needs to just have a look at? Because it's not something, I don't expect you to answer on the hoof at the moment if you haven't or the appellant's team hasn't looked at that particular element.
Perhaps I can just take some instructions. I mean, as we understand it, if the outstanding issue was about the ability of the upper floors to be served by an evacuation lift, I think the explanation that we've given provides the information that was being sought, because as I've explained, lift 1 could be used as a combined firefighting and evacuation lift. If, contrary to that, it was said to us that you had to have a separate provision for firefighting and evacuation lift, lift 2 would serve that purpose because it would serve the upper part of the building and go down to ground level. So we don't quite understand what further comfort is required from the council. But perhaps I can just pause, just take some very quick instructions to check I've understood the position correctly.
Yes, I'm more than happy for you to do that just for a moment. But I'm also happy for this to be taken away because it's something that I think can be either dealt with, we can come back to it at a later point, or it may be something that could be resolved and set out in the updated statement of common ground, for instance.
Very well.
Something like that.
Yeah.
So I'm quite happy for that.
I think that's probably a good idea, ma'am. Perhaps can I just take instructions very quickly to confirm that I've recorded the correct position so we leave this on the correct basis?
Absolutely. Happy for you to do that.
Yeah.
Okay, ma'am. I think.
Mr. Linus.
Thank you very much. I think just to tidy this up, we should take this away from the inquiry. We think that the matter that needs to be tidied up is just to confirm with the council an explanation as to how we can use lift 1 and lift 2 in particular to deal with the upper floors. We can deal with that outside the inquiry. We don't anticipate there being a problem given the explanation I provided to you today. And we can liaise with the council as to exactly what they're expecting from us in that respect. But I don't think it's going to be useful to spend much more time on it today because we're confident it can be resolved.
Madam, I'd agree with that. Could I just point out to my learned friend, he just said before he took instructions that lift 2 goes all the way down to the ground. Now, no. I don't think that's actually right based on the email that I've seen from Mr. Marshall.
No, lift 2 serves the upper floors, but obviously goes down to the ground because it doesn't just stop at lift 12. That's what I meant. Lift 1 serves all floors, goes to the ground. Lift 2 serves the upper floors, but goes down to the ground as well.
Okay, fine. Yeah, I'm cautiously optimistic, madam, that when we have I think sensible discussion offline, bottom out exactly where lifts go and so on, well, cautiously optimistic we'll find we can deal with this spike condition because there are enough lifts around.
Thank you. It may be something that we come back to later on in the inquiry, just to make sure. I will leave it to yourselves to try and come to some resolution on this particular point, or to agree to disagree, whichever it may be. You know, as long as I'm aware of exactly where everybody sits in relation to this matter.
I'm confident we can reach agreement of this. I think it's just a case of tidying up a perceived loose end. We can do that.
Okay, thank you, Mr. Linus. Thank you. That brings the round table.
Madam, sorry, I believe Mrs. Watson has a hand up.
I know, I've just noticed, Mrs. Walker, that you've just put your hand up. Mrs. Walker.
Sorry to take up time.
That's okay.
I think I've understood, but I'm confused when they kept saying about using lifts in the event of a fire, because clearly you don't. So is this the lifts that the fire brigade use in the event of an evacuation? Yeah, because, you know, we're always told do not use a lift in the event of a fire. Now, I go back to the Grenfell fire, and I still have real reservations about converting this old concrete office block decaying into suitable accommodation for people. And the 24/7 use of electrical equipment fills me with dread. And in my earlier 2019 thing, there was somebody at the GLA said there were too many flats on a single core. I still think that's the same today. How many staircases are there? Because there was only a single staircase at Grenfell, which hindered evacuation. So it's all about evacuation. Okay, so it's just a worry that people can get out in the event of a fire.
Thank you, Mrs. Walker. Mr. Linus, would you like to just respond on those points? Or would you like to bring Mr. Marshall in?
Just Mr. Marshall, do you have anything to respond to on that matter? No. No. I mean, if the broad concern is being raised about the conversion of the building to residential use, it really comes back to the issue that's been discussed. This has been through discussions with the GLA and the council, and the sole issue is how you cater within this building and the lift provision that's already there for fire services and evacuation. No issues ever been raised by the GLA about the fact that one's converting this from office to residential use, and no issues been raised by the council in that respect either. And as for the point about evacuation strategy, as Mr. Marshall's already said, and you'll see in the email, the understanding, the starting point is that the firefighting strategy is a stay put, and that any evacuation that does take place is done by asking residents to stay where they are, and they're evacuated accordingly. But in the event that an evacuation is taking place and a lift is going to be used, then the entire purpose of this discussion has been to ensure that lifts are available for that purpose.
Also, just to add as well, it is a two-stair building. It's not a single-stair building.
Right. Okay. But in Grenfell, the stay put failed. So why introduce a stay put policy? By 200, you know, they died because they stayed in their flats in an old concrete building converted. And we haven't heard everything yet, have we?
Well, we're not dealing with Grenville. This is a completely different development. So I don't really want to hear about the awful things that happened at Grenville. A complete and utter tragedy that occurred there. But what I want to focus on here, looking at the evidence and hearing what I'm hearing, I need to just make sure that the authorities that are required to consider fire safety standards are content with the proposals as they are set. So thank you, Mrs. Walker. Anything further on the fire safety roundtable session? Because I'd like to bring that one to a close. Obviously, if necessary, we will reopen it depending upon future discussions about everybody's positions in terms of the two main parties, etc. And so we'll see how that goes. So thank you for your input on those two roundtable sessions. Now, I am aware that it is now 4:15. We do need to have a break. I would like, but obviously this will be at the agreement of those present. I would actually just like to continue and to have the presentation. Otherwise, I think it would then delay things on Thursday moving forward, etc. if we were to push that over onto Thursday. And I'd rather not go into tomorrow. I think it would be better if we can just finish it today. So if I can suggest that we literally have sort of a 5-minute quick break and then come back and have the design presentation, or a 10-minute break, and then the design presentation, would that be acceptable from the main parties that are present? I know that would be delaying staying on here, but we then won't be sitting tomorrow. So it sort of partially makes up for it.
Ma'am, from our part, that would be absolutely fine to sit on, of course, and we'd be grateful for a 10-minute break, just because Mr. Taylor, if it's acceptable to you, was going to share his screen. I know that it's not something we would want to do generally through the inquiry, but this might be one.
This is one, absolutely, yep. This is one time where I will accept that, yes.
Thank you very much. So if we just have 10 minutes just to get the right people in the room and make sure we can share the screen properly, that'd be very helpful, thank you.
That's fine. And Mr. Burton, is that acceptable?
That's absolutely fine by us, madam. And I believe, Mr. Linus, we're estimating, Mr. Taylor's estimating about half an hour, is that right? Is that something like that?
That's about right. A touch over, possibly 35 minutes, possibly.
That's fine. Well, as I said, there won't be any discussion on the presentation. It's just literally the presentation. So if I can ensure that everybody's back then, and let's go for 4:30 then, please. That gives just over 10 minutes, and then we'll have the presentation. So thank you very much. I'll see you at 4:30. Mrs. Walker.
I will be leaving now. If I'm required again, would the council let me know? Because I won't be watching anymore. I've had to come out of my house because I don't have Zoom at home. I'm in the council building, so they have to set it up for me.
I think what I will do is I'll make the program available, and if there is anything on the program where you think, oh, actually I'd really like to question that witness, or have the opportunity to question that witness, if you can then let the council know.
Right, that's lovely.
Okay, so you look out for the program when it comes out. Okay, all right.
Sending that to us. Is it Leanne, the lady?
It is my case officer. Yes, in Pens. It's yes, Leanne Palmer. Yes.
That'd be lovely.
Okay, thank you, Mrs. Walker.
Ma'am, I'm sorry to interrupt. If we're going to share the screen at this end, apparently we need permission from the host to do that. I see Mr. Feltham seems to be designated the IT representative for the council. I'm wondering if he's aware of how we can achieve that.
Do you need to get on to your IT people, Mr. Feltham?
So have you tried to, because at the bottom of my screen I've got a share screen, but you're saying that doesn't work for you?
No, it doesn't. I understand. I'm just, excuse me, just for one moment.
Okay, yeah, fine. So I can do, all participants can share.
Yes, the Zoom message that we have on screen when we've tried to set up the sharing says host disable participant screen sharing. So we need the host to enable participant screen sharing.
I think I have just enabled that.
Right, we'll try that again if we may.
Well, if we can all be back at 4:30, I'll leave you to resolve that.
Okay, thanks very much, Mum.
Yes.
Thank you.
Thank you.
Yeah,
it's working.
It's working.
Yeah, thanks very much, Mr.
Okay.
Feltham.
Hello? Yeah, speaking. Yeah, good, thank you. So I'm in the middle of a public inquiry at the moment. We're just on a very short break. Okay, yeah, okay. Yeah, I'll do that. Okay, cheers, thank you. Cheers, thank you. Bye.
Welcome back, ladies and gentlemen. Now, I think there's going to be some screen sharing. I do have a copy of the presentation, which is on my other screen, because I can see it because it's much bigger. But obviously, I need to just know which one you're talking to in terms of the presentation slides as you go through. Okay. So if you want to, I think it's Mr. Linus, it's over to Mr. Taylor, is it? Oh, there is an awful lot of feedback. That's because people in the same room have got their microphones on. Yeah. So I think it's going to have to be one person at a time if you're in the same room.
I'll hand over to Mr. Taylor on that list as well.
Thank you, Mr. Linus.
Thank you. Good afternoon, madam.
Thank you, Mr. Taylor.
There is a bit of feedback, which is quite difficult. Is it possible? That's better. It's difficult because I've got an echo in my ear.
Yes, it's rather off-putting, isn't it?
It's just, I mean, there's two of me, which is worse than one. If you could bear with me a second whilst we try and resolve that.
I suspect the only way to resolve that is either everyone else turns off or turns their volume down to.
Is that better? Can you still hear me?
I haven't got any feedback at all. So you're coming through loud and clear, Mr. Taylor. Are you?
Right. Can you hear me now?
Yep.
Brilliant. Thank you very much. I will attempt to, as we've sort of got the sort of graveyard slot, I will try and get through this as quickly as possible. But as you've probably been made aware by all the reading that you've done, this is quite a complex development and has been a lengthy process in terms of discussion and design development. I would like, if I can, just to sort of walk you through a little bit of background context of the design decisions and why we made them, then followed by a sort of description of development that we have achieved, and some of the reasons why. I should say that in the process of the design, it's been conducted in a very positive manner by all parties, particularly as this is one of the first schemes that we have done that during pandemic where everybody's been online. So we've had pretty much all of our pre-apps and consultation process by Zoom or Teams or whatever. And so we've all had to learn that, but it's a slightly different way of doing business. But actually, I think has resulted in the wider team coming together. And as I said, it's been a quite enjoyable and very positive process. In sort of starting off, I think it's fair to say that there is a sort of an agreement, I suppose, common ground in design that the council have expressed that in visual terms, height massing and townscape is they don't have a problem with and are supportive of, as have been the GLA. So I think from our perspective, the principles of development are not in question. Maybe some of the detail, which will come out over the next few days, are, but certainly the principles and the general sort of desire by all to see some regeneration and refurbishment of, I think, what everybody believes to be a sort of a landmark building. So if I take you on slide 2, which I think it brings to life the urban character of the Tolworth complex in a sort of suburban environment. But that's a deliberate decision that was made well before my time and well before our time in the sense of the density of development, the height of development, the mixture of uses of development. And certainly from our perspective, the intent that both Tolworth and the council have shown in vision for both this area and all the areas around Toby Jug roundabout have suggested that there is a strong ambition for future positive development. I think it's important, I think, to identify in this that the tower itself, as far as my sort of knowledge of this tower over the last many years, has been a gateway. It's a gateway to South London, to Greater London. It's a marker in the A3 down to the south coast. It's a really important marker and a really important entrance to Tolworth. So with that in mind, it has a wider significance than just a building on this site. The scheme itself has been serving the community for a significant period of time, but that marker, as a number of people have mentioned today already, has started to deteriorate, and therefore our job was to look at how best to vision its future. If I take you on to the next slide. This is a sort of combination of images that we've taken from what was the Tolworth area plan. This has been referred to today already and in evidence on both sides. Although it's still, as Councillor Walker mentioned earlier, it's been parked because for a variety of reasons. The ambitions and illustrations that were contained in it were very much part of the context of how we started to think about what the Tolworth Tower complex would be. So from our perspective, there are images in it that talk about building height, ambition, and uses and such like. So that's been very much a directive for us as to influencing the way that we've been thinking. You can see, I think it's quite important to demonstrate with the sun path how the site orientates itself in terms of north-south. I think you can see on this plan the purple where you've got significant development on the other side of Toby Jug roundabout with the Hookrise residential scheme mentioned earlier, the Lidl headquarters, the Premier Inn, significant development. And I think it's also worth mentioning that the Tolworth station, albeit the service is not brilliant, but has room for improvement, is between 5 and 10 minutes walk from the development site, but also Alexandra Park, which is, I think, just under 7 hectares of land, of park, including the tennis courts and football pitches, is within 10 to 15 minutes walk of the site. So there is significant, it's almost as if the site forms a bit of a knuckle, a bit of a hub for the surrounding district. Very positive contribution in terms of its profile within the uses along Broadway, and you can see the ambition for the commercial extension as it follows the Broadway to Ewell Road. If we take you on to slide 4, it's worth just exploring the ground floor plan as it exists. As I said, this is a highly complex development, and I think part of the reason for that is that it has a series of legal agreements and leases and that overlap each other above sort of four levels of basement and podium, plus obviously the buildings on top. So each of those has slightly different uses. So what was shown on this plan is the red line really shows the site that's available for improvement and development, and the site that's outside of that red line within the blue line is untouchable. And so that means, for instance, you can see the Marks and Spencer's store. That is quite a constraint in terms of both the occupation of the retailer, but also in our ability to do things above in relation to penetration of that building. But as you can see, both the hotel entrance to the northwest on the plan and the Tolworth Tower current entrance that brings you into the tower and also to North Point to the northeast, and then obviously as you come down below the Marks and Spencer's plan, you can see that you've got the entrance to Marks and Spencer's itself in front of its 56 car park spaces. So it's actually quite a well-developed and well-used ground floor. The car park under Croft in the ground floor it has a clear height of about 4 meters, so it's pretty generous, but it's a little bit dull and confused at the moment. And so part of the opportunity for us is to take the infrastructure and the existing fabric and make it better from both security and wayfinding perspective as well. On the Broadway, we've got the existing retail, which includes Boots and Costa, and you can see the entrances for those. You've got the one of the units is now occupied by ShedX, which is a community public realm, a charity that we've been working with in terms of public realm along Tolworth Broadway. And then you've got the empty pub with and the space above, which is the sort of back of house for those units aren't used anymore. The key thing for me is that we have, and by doing what we're doing, is we're maintaining the positive approach of M&S to Tolworth and to Tolworth Broadway. So by enhancing and refurbishing and repurposing aspects of this scheme, M&S becomes stronger and more relevant to the Tolworth Broadway. I think that covers all. If we go on to the next slide, please. Again, what this illustrates really very simply diagrammatically is that there's a 4-story podium, including a basement, ground and first and second car parking. Currently I think it's 647 spaces, roughly 180, 190 on each floor with about 80 in the basement. The hotel is 135, 132 rooms, which sits directly 6 stories above the podium and identified on the plan in purple. The North Point residential conversion, as discussed earlier, that was refurbished and reclad some years ago. It now provides a sort of very positive contribution to the composition, but doesn't allow us to do very much in terms of the refurbishment because obviously it's a static occupier. The office building itself sits below ground, and then it has ground and first floors, which vary in floor to floor height, which is quite unusual. And then once you get to second floor and above, it's offices all the way up to 21. And then there's a plant level above it. That plant level, we have sought to and got resolution to grant to convert that plant level to homes. So that gives a sort of sense of where the massing that currently exists. An important point really is also the car park to Marks and Spencer's. This has become quite difficult in terms of being able to do anything to facilitate public realm because it's under lease, it's been consented as a car park, and so although it sort of it has moved away from Richard Seaford's original plan of fountains and garden, it's impossible currently to do anything with it because of those legal constraints. We'll go on to the next slide. In terms of the history of the site, interestingly, in 1959, an application was made to Surbiton Council for 3 buildings on the site, which is shown illustratively on the Surbiton News extract above. That resulted in the application for the Tolworth complex, which was undertaken and designed by Richard Seaford. The application submitted in 1961. Excuse me, as 60-year-old buildings, similar to 60-year-old people, we are not everything works as it should have done, and it should do, and therefore the building itself is in dire need of some tender loving care and some refurbishment. The services provision is inadequate. The external glazing is single glazed, and there are water penetrations, but actually it's beautiful. I think you'll find that most people who have a view on the Tolworth Tower think it's a beautiful building, and I have as an architect, I have no qualms in my opinion. This is one of Richard Seaford's better office buildings. It has limitations in terms of it's a 15 meter by 60 something meter long floor plate, so it's unusual in terms of its floor plate provision. It's floor to floor. It's okay, but once you get raised floors and suspended ceilings, it becomes more challenging. Its structure is very delicate. It's got beautiful structural exposed elements. The pilotis coming down to ground, as you can see on the image. But also the structure, unlike many modern buildings, is designed to a minimum, and which is one of the reasons why the lift shafts are openings, as we discussed under the fire review earlier, are only open on certain floors, because the lift shaft in the building acts as a vertical beam which holds the building up. And so the engineers have said categorically we can't punch more holes into that. So we're using the existing lift shafts with the existing openings, but give us the coverage that we need to support the fire strategy. But unfortunately, the structure is fragile, and certainly the opportunity here is to take this beautiful building and try and put back something that satisfies the energy and architectural requirements of a more contemporary modern building within the context and language of the building that exists. And it's interesting, if you look at the language of the elevation, the horizontal spandrel panels at slab level and the tinted glass both above and below, you've also got the verticals, as you can see the structure through the glass all the way along, so the regular rhythm of verticals and horizontals. And it is, and I'll come on to that when we talk about the architecture of the new scheme. The importance for us is that there's a tapestry of both material and form there that I think we've learned a lot from and have some benefit for us going forward. So if I can take you onto the next slide. As part of the context and part of our sort of ability to learn from what's happened, over a period of years, there have been a number of planning applications, and what's in front of you is the resolution to grant in 2019. This is a comprehensive refurbishment approved by officers and resolved by councillors, subject to a 106, with a comprehensive refurbishment of the facade, double glazing. But as you can see, trying to pick up on the spandrel panels and the horizontal emphasis that exists within the existing building, keeping the structure as illustrated, but trying to look at how the glazing bars and the internal walls come together not to create a confused elevation. And I think we worked quite closely with officers to get to this position of the architecture of the refurbishment, because it was quite a delicate process of taking what was there and replicating it, but doing it in an energy efficient and sensitive and respectful way to what has been done previously. And you can see that includes openable windows to all of the apartments. And you know, so 261 homes over the 22 stories. It's a very, I think, a very positive contribution to the skyline. As part of the planning history, which is also quite important for us, was the resolution grant, which I think came through in 2015-16 for the comprehensive redevelopment of the site. This shows a photo image of an earlier iteration of the scheme, but nevertheless, the building heights and adjacencies remain the same. And that had a 5-story, 15-story, 12-story, 19-story building. But it tended to have a sort of closer proximity to the tower. And it's not my job in this process to criticize other architects, and so I'm not going to. But the objective here for us when we were commissioned was to learn from the consultation process that had gone on in relation to this scheme and see whether there are any areas that we could improve with a different brief and a different boundary line to work within. So, for instance, this scheme proposed that the M&S car park in front of their front door became the public realm that Seaford visioned in 61. Well, we can't deliver that. So therefore, this scheme could no longer be sustainable in that context. There were comments to do with I think Councillor Walker mentioned this earlier about the fact that the buildings one of the buildings had 9 units per core. And so we felt we needed to design that out and come up with a solution that brought it back to the 8 units per core as GLA have prescribed. We also wanted to try and reduce the number of single aspect flats that this scheme brought forward to approval. But again, this was a dense development supported by and recommended by officers for approval and supported by council members at the time. So again, there's a lot to learn from this in terms of how we approached our design proposal. I come on to the sort of, I suppose, the vision for us, the concept, and the clear considerations here are North Point and what we call T1, which are fixed assets that are not. There's nothing we can do with it. There's also the M&S underneath. So the development area that we are constrained to use, and looking at the development, the concept analysis that was done as part of the previous approvals, led us to the fact that we should have a centralized public amenity space, a new raised area that becomes the heart and the focus of everything that goes on this site, that every building element has connection to. A substantial space that's 100 meters long by 22, 24 meters wide, a space that actually is almost the same width as the Broadway itself, which would be to the benefit of all the residents and the community that we were seeking to build on the complex. And then to facilitate that, we then looked at 2 additional buildings, simple but elegant. I'm loath to call them towers because 2 buildings of similar heights to the buildings, 15 stories and 19 stories to what was resolved to grant some years ago, and work within the constraints and the boundaries and the heights that were determined at that time. So we didn't feel we were in conflict in progressing. We then had a number of pre-apps and presentations to the design review panel, whereby we took on board the comments from those consultations. And one of the questions was in terms of loss of retail, for instance, on the Broadway. And you'll see the analysis that was done on the lower plans on the screen. We gave the officers a choice at the time and said, we feel we can achieve both of these. What is your preference? And the preference came back that they preferred the plaza rather than actually now clearly they would like to have had both, but the plaza was actually much more relevant to what we were trying to achieve as a stop-off space on Broadway in this complex for the pedestrian and public. So we chose that route, and that's the route we pursued as part of the concept development. Interestingly, when we showed that to the design review panel, they were supportive of that plaza. Their question to us was that they wanted us to make the ground floor a 2-story representation elevationally, because they felt it should tie into the 2-story podium above ground that exists around the outside of M&S, which we subsequently did, and I'll come on to show later on. The next slide is a quite an important one, really, because right from the very outset, you will have come across the idea of city modelling that View City undertake. And so we bought the View City model, which covers most of Greater London. So what it enabled us to do is to plant the complex as a master plan into that model very early on, to start looking at sculpting the buildings to facilitate adjacencies, improve relationships with adjoining properties, to look at the spaces between buildings, to look at sun and daylight. And so from very early stage, we were involved in looking at the best and most efficient building envelope to facilitate those amenity facilities that we were talking about earlier. If I go on to the next slide, please. And this is quite important as well, because we then right from the very beginning, from the first pre-app with officers, we were talking about the previous resolution to grant and the verified views that were done for that approval, and what were the key views that we should be looking at in terms of the evolution of the massing of the scheme. And these were the 4 key views. The one coming from the A3 Tolworth Rise in the north, so you can see the tower in the distance. One from further along the Broadway as it joins Yule Road. One from Fairmead, which is looking from the east across to the buildings, and one from Hook Rise looking from the sort of southwest. Those were the key views that were identified for us to work with and come up with a solution that ultimately paid respect and looked at reinforcing and emphasizing T1, Tolworth Tower, as the critical element, and where the two new buildings that we're bringing to the table were subservient to that single building. Next slide. As part of that evolution of the modelling, we then went through quite a significant analysis of the microclimate in and around the buildings, which further shaped elevation, spacing, balconies, and you know, it's quite important that we've got several different type of balconies on the scheme relevant to their microclimate. We have looked at noise, we have looked at pollution, we have looked at daylight, sunlight, we've looked at wind, we've been in the wind tunnel several times because we wanted to get it as the best model that we could to facilitate the scheme that worked best for both visitors and residents alike. And again, what we've done here, this looks from the east across the site, and again compares to the resolution of the grant. Those are the buildings that were resolved to approve by councillors, and that's the 5-storey, the 12-storey, the 15-storey, and the 19-storey. And what we've done is that we have sought to improve and increase the distance between Tolworth Tower and the next building. So we've actually improved the daylight sunlight coming onto the central space and improved the daylight sunlight for North Point. And we've done the same between what we've called T2 and T3. So although our building heights are actually 19 stories and 15 stories, with the shoulders being at 17 and 13, we have much wider spacing, which means that we get much stronger daylight and sunlight onto the centralized public realm. This is the point. This is the image that Councillor Walker had identified as representing an earlier scheme in terms of the resolution to grant. But because we use this right from the very beginning with officers in terms of presenting the relationship between height and set out. So, for instance, you can see here that we have widened the line in red on the plan is the alignment of the resolution to grant buildings. You can see that we've increased the distance between T1 and our T2 to 45 metres. You can see that we've widened the gap between T2 and T3 from 11 metres to 18 metres. And you can see that we've actually increased the width from number 40 Broadway to the edge of T3 to 14 metres. So looking to look at ways that we can improve and bring daylight and sunlight into the central space. This is the ground floor plan that we proposed, and the entrance and exit points, travel lodge for M&S, for the residential lobby of T1 remain the same. The car park arrangement at this level, of which I think 142 of these spaces are allocated to Marks and Spencers, remain pretty much the same. The areas of difference are clearly the retail and residential entrances to Broadway. But I think importantly, and this is one of the key aspects of the design review panel, was the improving the route through the scheme from Broadway to Yule Road and back for pedestrians. And I think one of the reasons for this is that the buses that Councillor Walker referred to earlier was the fact that one goes to Kingston and one comes from Kingston. And therefore that transfer through the scheme is quite an important one. Although there are routes around the outside of the site, what we've deemed to do as part of the design is widened the routes improved the security, improved the lighting and wayfinding and materiality. So actually, it's a more successful journey from one side to the other. We've also shown where the Pilotis come down to the south of Marks and Spencer's. We've shown there that we've got a new access up to the first floor to our flexible workspace. We've got a new lift that's on the edge of the M&S there. You can see that brings you up to that workspace. So it can be an independent use of that area without having to go into the main residential. And then around the outside of that, we propose to put sort of kiosks, that sort of the coffee and the donuts and whatever that you get that actually feed off the customers that are coming to M&S. Important on both of these is the disabled and car sharing that you see to the east of the Marks and Spencer's, which then takes you down to the existing basement entrance, which is remaining as it is. Again, the structure of the Pilotis and of the main tower hasn't allowed us to do very much in changing that access. So although it's, if you've been down to site, you'll see it's quite a low headroom. I think the basement level has got a headroom of about 2.5 meters. It still provides a significant opportunity for use of the basement. Next slide is an enlargement of the area and the plaza, really, this is an 18-meter square plaza. So it's not a small space. It's got significant mature planting. We've got a green wall to screen the car park behind with access through it. We believe that having the residential entrances where we are, we've got a footfall of pedestrian and public coming through that space. It's a multi-purpose space. We've talked with, as I said earlier, with ShedX about how we might improve the public realm along the Broadway and through that space. And we fully envisage that this is the commercial uses on either side, which we have to accept is less than what's there at the moment, but have much more value as part of the community of the scheme, because what they're doing is they are allowing us sort of a longer duration of occupation through cafe and bar and restaurants that we would expect. You will also see to the left of T3, we've got the bike lift that takes us up to the first floor bikes for T2 and T3. We've got a new stub station, and you can also see at the back there a public realm store. So there's a lot of detail in these plans in terms of understanding both what visitors need and what users need and what the occupiers need who live in the homes above. And some CGIs really of the quality of those space. We really believe this space will be a very active and positive contribution to Broadway. You'll see on the left the materiality and the winter gardens that sit above that space, and the mature planting and green wall to the rear. Next slide, please. And this emphasises it a little more from the other side of Broadway. Again, you can see the scale of this space. 18 meters, as I said earlier, the width across Broadway, which is a pretty wide thoroughfare, boulevard, for want of a better word, which is 26 meters. So it just gives you a sense of scale and relationship to the buildings. I'll come on to talk about the architecture and materiality of T2 and T3 a bit later. The basement illustrates the route down, which I showed earlier on the ground floor plan. You can see down here that we've got car parking for North Point. We've got about 400 cycle park spaces here for the T1 and North Point. But this is where our refuse collection is again, and the refuse across the whole development. This is part of the comprehensive nature of the way this works, is that we are feeding in a managed way all of the refuse from all of the buildings into this space. And you'll see just to the north of where those squares are is a lift access that takes you up to the service yard behind M&S. And it is from there that the refuse lorries will pick up the refuse. This lower level has a substantial amount of plant underneath the T1, but we're lucky that there's a basement of this scale, really, because the cost of doing something like that on a modern development is significant. That's why the basement below T2 and T3 is relatively modest, and here it's cold water tanks, switch rooms, relatively simple lower level plant area. This takes you up to the first floor, and as you can see, if I take my cycle lift up from the ground floor, you can see the resident cycle parking to the north of T2 and T3. At this level, we've got seven apartments that sit in those buildings, disabled spaces directly outside, and the car parking here is a combination of the hotel and residential parking. You can see the upper level from Marks and Spencer. So we, as I said earlier, the sustaining of this development and repurposing of this development is allowing M&S to trade with about 40,000 square feet of shop here, which is not a small. It does provide a significant anchor at the end of the Broadway. And as I mentioned earlier, you can see the sort of the brownie color workspace under the Tolworth Tower, which is our flexible workspace, which has direct access from the outside. This is the public amenity, public realm that I discussed earlier. The program of activity here, I think my colleague David Price will be talking more about later in the inquiry, but you can see here it's a combination of activity there's a circuit that goes all the way around Travelodge and North Point. You've got tree planting, you've got allotments, and it's, as I said earlier, it's about 109 meters long by 22 and 24 meters wide. That's a significant space and will actually be a real hub of activity for the community. All of the buildings, and you can see the hotel don't have access into this space, but you can see the access from T2, T3, and the amenity level of T1, which is where we've got the meeting rooms, the gym, and the general amenity support for the tower. And that's a view looking from one of the apartments in T1, looking at how the space might work. Clearly, this is a CGI. We have had significant structural analysis of the deck, and to ensure that this replacement of the second floor car parking. But as you can imagine, with all those car parking spaces, of which the current scheme has about 180 spaces on level 2. The loading that would imply through the structure is sufficient to allow us to have a reasonable landscape scheme up here. There is a design that allows the tree planting, for instance, to be directly above columns, and I think it's fair to say that if we look at the BRE guidance of March the 21st, this achieves, I think, 53%. So in excess of the minimum requirements for 2 hours on March the 21st. Just to further illustrate that the T1 generally has 14 or 12 apartments, homes per level. There are 4 lifts servicing that building. There are 2 staircases servicing that building, and it's the width of the width of the building works for residential use. When we're designing the buildings for T2 and T3, we have tended to try and achieve a more efficient net to gross in relation to the efficiency of the building, which actually helps its energy efficiency. So again, it's a single stair building, 2 lifts, one larger, one smaller, but for furniture and pedestrian movement. These are the T, as I said earlier, the T2 goes up to 19 stories and T3 goes up to 15 stories. and there are again a mixture of 1, 2s, and 3 beds. The roof level of the T2 and T3 is where we've got their air source heat pump, lift overruns, and PVs in relation to decarbonisation strategy. And it's worth looking at the 22nd floor now for the T1, which is actually, you can see it's recessed because that's the line of the current plant on the top floor. And we've got less units up there, or less apartments up there to make that work. But again, fantastic place to live. The amenity space at level 13 and level 17 on T3 and T2 is over 6 meters wide by 24 meters long. So it's material. And it has a well-developed program which David Price will come on to talk about later. And the residential amenity, all apartments are sized as a minimum at no less than the national design space standards and the GLA standards. So we are providing significant quality of living accommodation. All the apartments on T2 and T3 have balconies. You'll see on T3 that the two smaller units to the east have inset balconies because we can't sail over the car park there to M&S. You'll see that the balconies to the 2 homes on T3 are winter gardens because we felt that because of the microclimate, they would be better suited to be winter gardens. And we've used the corner balconies as a reflection and a reference to the design of Tolworth Tower 1, and I'll come on to talk about that shortly. And these are the verified images that were part of the application. The same 4 images that you saw that we as part of our massing evolution, and we feel, and I think it's certainly reflected in the GLA response and the DRB response, and certainly from the council's statement of case, that there is support for the height, massing, and townscape that these buildings bring to Tolworth. Looking at the architecture of Tolworth 1, excuse me, it's, as I said earlier, it's a beautiful building, but it breaks down into very sort of simple elements, which is why it's beautiful. It's not something that we'd probably be able to justify currently, because I think there are various different regulations that would have not allow us to do that. But you can see the geometry of the building is very simple. It's symmetrical around the gable, Broadway elevations, east and west. You've got a very simple rhythm in terms of the architecture of the facade, the materiality, the structure being exposed, which comes all the way down the building. It's just beautiful. It's elegant and very simple. And what you tend to get on what is actually a pretty large building is quite an interesting texture, and that's shown by, if you look at the image to the far right on the bottom, the texture of the pilotis made up of these tiles. This is something that we are picking up on and bringing into the new building. You look at the pilotis and the way they're sculpted, and they come all the way down to the ground. I talked about a waffle slab earlier, which is part of the structural solution for the building. You can see that exposed under the second image from the right, and then the corner details and the fins. All of those are very simple but very elegant interventions in terms of creating the architecture. We have then, as far as those elements are concerned, in Tolworth Tower on the 3 images, on the one on the left, we've actually utilised the horizontal extrusions for the slab, where the slab sits. We've also got glass, painted back glass in the up to the sill. We've got, you can see, I think it's shown as 2. You can see where we've got obscure glass there, where we've got a partition coming into the back of the wall. But what you can see there is, again, a very simple reflection of the external fabric that exists within the Tolworth Tower currently. If you go on to the new building, we found that there, as I think I said earlier, there is a tapestry or matrix of levels of definition here that include sort of very strong vertical elements, very strong horizontal elements, and a mixture of different textures. When we presented the thoughts to the design review panel, they were supportive in approach. I think they said to us at the time that we perhaps had too many materials, so we reflected on that and actually reduced the number of materials. So we've got the glass, which it represents about 32% of the elevation. That's as efficient as we can get in terms of daylight and sunlight, heat loss and heat gain, and so constantly thinking about the energy usage within the building. And the balconies, as I said, reflecting the wings of the T1 tower. The materiality that we've chosen, to use colour tiles, and we to determine these with officers, but on the top left-hand side, we have the sort of greeny blue reflection of colour that exists in the existing building, which you don't actually see unless you're close up. But that's a colour and a materiality that we're pulling through into T2 and T3. You can see in the second image the matte off-white tile cladding, which is using the tiles again similar to the pilotis of T1. You can see the build-up of glass that we've been using, the painted black glass that you can see in the next image, and then the perforated bronze color paneling that we'll be using as part of that composition. The window design is for both T1, T2, and T3 is critical in terms of its energy efficiency, and so it's quite important that we work closely with manufacturers, and it's fair to say that T1, because of its resolution to grant in 2019, has gone some way in terms of developing its technical detail to ensure that actually we can improve upon those energy efficiency as part of the evolution of the design. Next slide. This is the view from the south west towards the M&S car park, so you can see M&S. And what it tries to illustrate here is the very simple, very elegant vertical lines that we've talked about earlier, the materiality that reflects the corners of the pilotis within the main T1 building, the recessed balconies. So you've got this ability to have light and shade creating texture on the building. You can see the build-up of glazing. And the point I made earlier about the design review panel, you can see that we've now got a two-story podium level that aligns with the second floor landscape. And the other point they made was that they would like us to explore how we might finish the building off with a cap, which is how we've developed the sort of lid design for the top of the elevation. So actually, it's a very elegant, very simple, picking up on the elements of of T1, showing structure going all the way down to the ground, supported off the ground. There's no false applied detail here. It is purely and simple, a sort of, I suppose, elegant reflection of the building fabric. And that's the reason I put this in is because the view from the 22nd floor of T1, looking down onto the public realm, you can start to see the importance of that in terms of it's a bit like having a lung in the middle of the scheme that's breathing. You can see how the T2 connects with the ground, the structure going all the way down to the M&S car park level. You can see the connection at a podium level for the flats and the apartments that look out across that, which have their own private amenities straight outside their front windows. I think the elevation on the left also shows brief section of the car park, and so you can see the 4 meters clear at ground floor. You can see the 2.5 meters clear at basement. But you can also see how the first floor car park is not as generous in terms of floor to ceiling height. So we're working within that to align all the levels. And finally, this illustrates the corner detail I was talking about. One of the most beautiful details on T1 is how the floors angle out at the corners, creating that beautiful shadow. What we've tried to do is to do that with the balconies on the corners of our building. It's very difficult to replicate because we're looking at wider buildings. We're looking at, but we've tried to use the simplicity of setbacks to achieve the slenderness of the Broadway elevation to replicate the T1. And that's what if you look at the elevation, you'll never see this elevation. It's a bit of a strange one to draw because you have to go back a long way away to see it. But the point being is that you can see the slenderness of the principal elements of T2 and T3 and how they are the same width as T1. We've taken the shoulders back to the left of each of those buildings, which are the darker color material taken from T1. And you can see we've stepped them down so that there's a gradual stepping down from the top of T1 down Broadway. And finally, this is the again, you wouldn't see this unless you were a drone, but it just gives you that illustration of a composition, a family of buildings around about a master plan that utilizes the amenity in the public realm to glue it together and feels comfortable in its setting. So thank you very much for listening. I'm sorry if I've gone on a bit and covered some of the ground that you've already heard, but hopefully that's useful.
Thank you, Ma'am.
Thank you, Mr. Taylor. That was very informative, so thank you for that. And hopefully it was also informative for anybody who also is watching now. So that was very useful. At that point, as I said, there's going to be no discussions about that. Relevant points will be discussed as we start to come forward start to progress through the rest of the inquiry programme. I think this is now a suitable point to adjourn the inquiry until Thursday morning. So thank you very much, ladies and gentlemen. We will start on Thursday morning then with Councillor Dunstone and then go immediately into the council's first witness. Okay, so thank you very much, and I will see you on Thursday morning at 9:30. I will be issuing a revised, it may still be draft because it's still flexible, but a revised programme. So if the main parties, I will let the main parties have a look at that tomorrow and then get it issued onto the website. So please have a look at it and see if anything needs altering, etc. So thank you very much, and I will see you again on Thursday morning at 9:30. Thank you. The inquiry is now adjourned. Thank you.